is on business ethics and business practices, and all of the content is specific to the staffing and recruitment industry. I'm going to take a second here to figure out how to share the PowerPoint screen and get it loaded up. And I'm going to assume you can see that, but if you cannot see that and you do not see the opening screen, then please demute yourself and jump in and let me know that we're having a technology issue. Otherwise, we're going to move forward with business practices and ethics. We've already covered on each of our sessions about the CPC, and then as you obtain your CPC, that you've got a bunch of different modules, legal aspects, health and safety, legal aspects of staffing, and legal aspects of recruitment. Two different sessions. Today's session, business practices and ethics. At a later time, I think you'll be covering recruitment and selection. I think that's next week. And staffing industry sales. And as I've mentioned several times, you've got a choice between these two, staffing industry sales and recruitment and selection. I strongly recommend that you do both, but in order to qualify to write the CPC challenge exams, you only need to do one of the two. Challenge exam is multiple guests, and you qualify to be able to do it at a time of your choosing once you've completed all your sessions. So you'll receive an invitation. So you now qualify and you can set yourself up to receive the exam and do it also online. Today, we're going to talk about the ACSESS webpage and the ACSESS Code of Ethics and Standards. We're going to use some case studies, and we're going to talk about some real life situations. We're going to make sure that we understand the professional ramifications of running an ethical business in the recruitment and staffing industry. And we're going to use some of the ACSESS resources to describe what ethical and unethical business practices are. And of course, in our ACSESS Code of Ethics and Standards, we make a commitment to uphold the ACSESS Code of Ethics as part of our application. And we also make a commitment that we will post that Code of Ethics on the wall or also in a public place, maybe on our website as an ACSESS member company. And we have, we have our ACSESS mission statement, which is to promote the interests and growth of the Canadian recruitment and staffing services industry. We want to identify and communicate and monitor industry standards and ethical practices. We want to positively influence and protect the regulatory and business environment that our members have to work within. And we want to also protect those that we serve, are mostly our candidates. Promote credibility and visibility of the industry to the business community, to governments, and public relations. So things like Staffing for Canada Week and our conference, and inviting ministers of labor, for example. I can't count the number of times that various provincial ministers of labor have come and become speakers at our national conferences, and making them aware of the type of content and the issues that we're talking about and confronted with. We want to provide our members with strategic support services, such as the CPC and other industry standards materials. So we talk about ethics. If you, in your first day of university in a business ethics class, you're going to talk about this moral philosophy. It's a branch of philosophy which seeks to address questions about morality. That's about concepts such as good and bad and right and wrong and justice and virtue, and what each of these means, and the slight differences between each of those topics. But at the end of the day, it's about doing the right thing. And so when we talk about ethics, and I'm gonna tell you that in my experience, and I helped build a staffing company from back in the 1980s, from zero, starting from scratch, to 7,000 contractors and temporary workers a day and 24,000 jobs filled per year. We were a big company before I left the industry to do this sort of thing 10 years ago. And I really feel like the thing that made us differentiated from many companies were the known fact that when it came to things like workplace health and safety, not because we wanted to get an award or because we wanted to get a rebate, because we cared about fingers and toes, because we wanted our mothers and fathers to go home to their children safe, and that we wanted them to earn a living that could give a decent living to their children and their families, and they could look after themselves and each other and the people that they loved. And so we talk about what sometimes makes companies super successful and differentiate them, and those that have got in their DNA things like honesty and integrity and being accountable for the decisions we make and the actions we take, the respect for one another, for each other, the loyalty that we give to our team, to our company, to our coworkers, to our candidates, the loyalty we give to our customers, to our employees. This matters. It's felt. People feel it. People, when it's there, they know it. And that organizations that are focused on the things that matter, on the things that make a difference, the things that are of concern for others, like fairness and leadership, promise making and promise keeping, being we talk about in our sessions, in our two legal sessions, about being law abiding. And the point is, in business ethics and practices, it's not good enough to just abide by the law. That's the minimum standard. The Employment Standards Act, for example, is the minimum standard. That if you don't meet the minimum, you could be found at fault in law and you could be penalized, or you could have some action taken against you or forced to abide. But most often we try to set a higher standard than that. Truthfulness. So we started with honesty and we finished with truthfulness. So doing the right thing, doing the right thing right. So excuse me for a second. I just need to move some things around on my screen. In 90% of ethical problems we face, we know what we should do, but the real question, the real conundrum is whether we're willing to do the right thing. And, it kind of, there was a game, I think it was a drinking game. There was a game that we used to play many years ago called Scruples. And you'd have various people around the table and maybe a team, I can't remember, but you were given a conundrum, about whether or not you would tell the truth that might hurt somebody's feelings, or you might disclose some facts about something, or you might act in a particular way or protect someone or do something. You were giving a moral conundrum. And the thing that at an early age, like in my early 20s, I found that it was really quite extraordinary to see how different people can be given the exact same facts and circumstances and have a deep-rooted belief that the right thing to do is different from the person beside them, from all the people around the table. And then sometimes if you have 8 people playing, you might have 4 or 5 different variations of what to do, and 8 different variations of those 4 or 5 things of what to do. And we see this even more so today in the day of social media and artificial intelligence and social algorithms and siloed echo chambers of what we hear, what we read, and what we see. And we start to develop these opinions about what's right. And, all I can say is, does it feel right? Does it feel right? And does it feel honest? Because usually if it doesn't feel right and it doesn't feel honest, if it seems unbelievable, it probably is not to be believed. So we talk about the Code of Ethics Part 1, and we have 11 principles that ACSESS lays out. We're going to go through those 11 principles. But first off, to read to you verbatim what the ACSESS Code of Ethics says, this thing that should be posted somewhere on your website or each office wall. As members of the association, we commit to uphold this code of ethics and standards and display it prominently in our place of business. We support the principles set forth below and acknowledge that compliance with these principles is in the best interest of ACSESS member companies, their candidates, employees, their client organizations, and the reputation of the entire industry in Canada. And then we go on to lay out what those 11 principles are. So if we're all in the same room, we would do a poll and we would say who is responsible for ethics, and the answer is everybody is responsible for it. It's not just whoever's paying the invoice, and it's not just the customer or the candidate, but it is the recruiter, the customer, the candidate, the employee, the employer, ACSESS, our industry, the industry as a whole. We all have a shared responsibility in participating in ethics. Now, I want to tell you that years ago, this presentation, which was not originally prepared by me, but has been modified substantially over the years, really kind of focused on what the bad things were. And it said, we shall not do this bad thing and that bad thing. And we're going to define and describe this other bad thing and that other bad thing. And I always came away from it thinking, oh my goodness, I really think we should approach this in a more positive way. And of course, you can't really talk about what the right thing is without sometimes creating a contrast of what the negative thing is or the thing we're trying to avoid. And so sometimes we're going to have some examples that are going to be of the negative, and maybe not even have occurred to you before. And I hope that that's the case. But first principle is we will observe the highest principles of integrity, professionalism, and fair practice in dealing with our clients, our candidates, our employees, and all of the regulatory authorities, Canada Pension Plan, unemployment insurance, workers' compensation, employment equity, workplace diversity, OADA, human rights, employment standards. The list goes on. And will respect the confidentiality of records in accordance with the law and good business practices. So the first principle is much like as we talked about, the Constitution of Canada and the Charter of Rights and Freedoms. It is the big, broad stroke saying, here are the rules that will guide the rules. And so examples of these good practices are maintaining our promises of confidentiality, seeking out authority for disclosure. So in other words, a person is looking for a job and you want to present their resume to someone, you ask for permission to present their resume to someone. You just don't start emailing out their resume to everyone under the sun. Knowing and complying with all legislation and regulations, the bare minimum. Honoring our contractual terms. So we talked about the four different types of law, and one of those laws is contract law. And so when we violate the terms of a contract, we are violating the law in contract. We talked the other day about equality, fairness, equity, and it's all based around the concepts of respect, honesty, and accuracy in our interactions. So disclosing full information to our candidates, disclosing full information to our customers about our candidates. And so, in contrast, if you can hear my dog barking at the mailman, in contrast, some of the examples might be neglecting to perform reference checks, or even worse, falsifying a reference check when filling an order, misclassifying a worker. So, setting them up as an independent contractor and forcing them or telling them they don't have a choice to be an independent contractor when really they should be classified as an employee or a worker. Direct recruiting a candidate, rating, direct recruiting of a candidate that was previously placed. In most contracts between a supplier and a buyer in the recruitment industry, especially if those contracts are written by the customer, by the buying authorities, have got in it an anti-rating clause, which says thou shalt not recruit those candidates of which you placed in our organization or any other candidates that you become aware of during the course of providing us with a service. Misleading a customer regarding absentees, late. So information that you might have to this candidate, oh, they didn't do so well in our last assignment, and or they lost their last job because of absenteeism or something like that. So misleading a customer regarding information that you know, contacting a candidate's current or former employer for a reference without permission. Now, you might think that this is kind of okay, like they tick off a box and say, yeah, you have got permission to do references. But, my point is that be more specific. Even though they say, yeah, you can do references. Say, is it okay if we phone this company and who do you recommend we call there? And because the reality is that, a person might be currently employed, they might be looking for other jobs. They um, who knows what relationships they might have inside the company, or how people might use the information that you're thinking about. They're thinking about changing jobs in order to cause harm to that person, or to cause harm to the organization that they work for, or disparage the reputation of their supervisor who's having unfortunate turnover problems or something. So, seek out permission so you don't step into an unknown quagmire of problems that could come as a result of unwittingly providing confidential information that the person is looking for a job. So here's a question. Your customer is pretty big, temporary help customer. They're spending $800,000 a year in temporary and contract services with you, and they contact you with an order that's going to last for 4 months, and they indirectly hint that you restrict acceptable candidates on a discriminatory basis. Race, creed, color, place of origin, sex, sexual orientation, color, family status, record of criminal convictions, age. So they make some hints or suggestions that fall into the 11 prohibited grounds. And so how do you handle that? So here's some wrong answers and at least one right answer. You take all the details and you emphasize that you will work hard to provide the best candidate possible based on the required skills while adhering to non-discriminatory practices. That sounds like a pretty good answer. And it's bolded. Tell us that it probably is the right answer. Ensure that you get the detailed request in writing so that you can direct blame to them if you get caught. Well, geez, you're going to ask me to do something wrong. You better put that in writing. I'm not going to take the blame for this. That's not right. You do not knowingly and wittingly accept a discriminatory order, even if it is a customer. The customer is not always right. Hand the assignment to a tenured recruiter who is less uncomfortable with cooperating with discrimination, specifically with a big client. Well, that's sad. It's sad that somebody would say, oh, the more experienced you are, the more comfortable you get in doing the wrong thing. That's sad. Hand the assignment, go along with it if the discrimination does not relate specifically to a legally prohibited ground. Well, by the way, if it's not one of the 11 prohibited grounds, it's not discrimination. It could be a qualification. It could be a characteristic. But if it's not related to one of the 11 prohibited grounds, it's not specific. And of course, if you said, I'm looking for a hand model, you would probably want somebody with really attractive hands. And if you said somebody, geez, we're going to be doing a photo shoot of our jeans and for sale for our catalog, but we only have one pair and they're a size 8. So send us a person who's a size 8 so the jeans fit. That seems to make sense. We try to avoid the issues of physical attractiveness, unless, of course, it's for a model or for some job that's the actual point of the job. But keep in mind that it's not a prohibited ground. So it's tasteless, lacks sophistication and culture, but it does not necessarily break the law. Keeping in mind that ethical behavior sets the law as the minimum standard. So you play with that one. Inform the client that they will be obliged to use their company-specific criteria after you've given them a short list of candidates to consider. I don't even know what that means. I think that this point is supposed to be that, hey, look, I'm going to send you all of my qualified candidates regardless, and you decide. Use your criteria, use your company's hiring model, and you decide. And I guess that's fair, so long as they're not telling you that their decision points are based upon any of the 11 prohibited grounds, and that it is not characteristically offensive, whatever their criteria are. But if you knew, even if you knew what their criteria are, I think that we need to go back to the top and say, hey, I can't, sometimes you just can't even send candidates to a job knowing that they're going, what their culture is, that if it's a violation of ethical conduct. Principle number 2, we will provide leadership in the adherence to both the spirit and the letter. So the spirit is higher than the legal standard, and the letter is the legal standard of all applicable human rights, employment laws, and regulations. We will treat all candidates' employees without prejudice and will not accept an order from any client that is discriminatory in any way. So principle number 1 was the high arching principle, and principle number 2 specifically deals with the issue of discriminatory orders. So a discriminatory order, as I've already mentioned, is age, creed, disability, family status, marital status, gender identity, gender expression, race, related grounds. As I mentioned to you before, that sometimes a lot of the race and related grounds like color and ancestry and place of origin and ethical origin and citizenship, these are all similar but not necessarily the same. So the question really is, are you legally allowed to work in Canada? The receipt of public assistance is now considered to be a ground. You cannot discriminate against a person who is receiving social welfare, for example. The record of offenses, we talked about that, for which a person has pardon has not been granted. Sex, including pregnancy and gender identity and sexual orientation. So the client requests that we recruit millennials. I get confused, by the way, what terms are which. Millennials, is that same as Gen X? For a role of designer, the company is a startup, and they request young millennials. That's Gen Y. The company is a startup, and they request young, dynamic people to work with them. Well, we'll read the bullet points, and we'll come back to each one. The client indirectly hints that the recruiter only present female candidates. And in the third example, a client has a role for a forklift driver, and they must have their license to be able to lift 15 pounds. I think in most places the law is 25 or 40. They request to have Brian back, and if he's not available, then recruit another male of this role. So let's go through each one of these individually and have a little conversation about it. The client requests that we recruit millennials for a role. So this is suggesting an age group. And so when they say dynamic, that's okay. It's okay to say energetic, people with a bubbly personality, people with the type of personality that's outgoing and gregarious and wooful. You know, you can use those kinds of words because they don't describe an age. You're going to have people that are 18 years old and the people that are 68 years old who possess those characteristics. And so the fact that they're looking for a millennial is maybe that person's assumption that in order for them to be dynamic and energetic, that they also be young, but not necessarily the case, and not always the case, and not even close to being the case. A client indirectly hints that the recruiter only present female candidates for the front reception role. Listen, just on the face of it, I don't think we need to discuss that any further. You ask, about communication skills. You ask about the equipment that they're going to use. They ask about the location and the time of day and the pay and the number of people that they report to and the languages they must speak and whether or not they need to make some decisions and do other things like spreadsheets or accounting or approving things or something, buying stuff. So often the front reception desk has many roles and the person wears many hats. And so finding the most qualified person, not necessarily the most gender specific person, is the right approach to that. A client has a forklift truck. So, to ask for Brian back again, that's okay. It's okay to have Brian come and drive your forklift as a temporary operator and then say, hey, Brian was great last week. Can we have Brian back? That's perfectly fine. There's nothing discriminatory, prohibitively discriminatory about the request to have Brian back again. This is a person who's got experience and is familiar and all of those things and has proven to be good. And all of those reasons are reasons enough to be able to ask for Brian, who I'm assuming happens to be male. And if Brian's not available, then they need to recruit another person who has the same skills and experience and knowledge and demeanor and effort, commitment to effort as Brian. That's fine, but not necessarily, not specifically, not requesting another male person. Principle number 3, we'll take all responsibility and steps to provide clients with accurate information on a candidate's employment qualifications, experience, and we will only present candidates who have given us the authorization to represent their application for employment. So this is really 2 things. This is about honesty and accuracy, and this is about privacy. This is about privacy and authorization. And so we've got 2 concepts here that go together very easily. The little buttons on the right-hand side, honesty is the only policy for success. There is no case for dishonesty. So here's an interesting one. This is the treaty group, and just by coincidence, someone else put this case into this PowerPoint presentation. I was hired as the expert witness on behalf of one of the parties to provide a report on what the industry norms and standards were with respect to background checks and reference checks, and to describe what the normal process of onboarding a candidate is when there's a recruitment agency involved in the recruitment of the candidate. And so I've got some insight, and so I've added some notes to the next screen and to this screen. I've changed things around a little bit to kind of reflect what really went on there. So this placement agency suggested the employment of an employee. So they presented a candidate to the treaty group without checking the employee's references. The company hired the employee, and the employee worked for the company for 2 years. And then she resigned. And she basically resigned because I think she was stealing. And I think she thought, I think I'm going to get caught, so I better get out of here before they figure it out. And so after the employee resigned, the company did, in fact, become aware that the employee had been defrauding it. My recollection was it was over $200,000. I think it might say on the next screen. The company sued the employee, and they also informed the police, and they obtained a civil judgment against her to pay them back. They also sued the agency for negligence on the basis that the agency did not conduct a reference check or a background check on the employee. So it was found that prior to joining after the fact, when they went to discovery and went to court, they found out that the employee, had twice in the past been criminally convicted of fraud against previous employers. So this individual had a pattern of going into jobs where they had responsibility for accounts payables and accounts receivables and stealing from their employer. And after joining Treaty Group, the accounting department, the employee walked away with an additional $263,000 that they stole. When the Treaty Group discovered the fraud, it reported the matter to the police. The employee was convicted criminally of fraud, And then the treaty group sued the person, trying to get the money back, because it's very common in a criminal case that there's not restitution. So there's a penalty. You're going to go to jail for 5 years, but there's not necessarily restitution. They might say, if you don't tell us where the money is, you're going to get more of a penalty, but they don't say necessarily, and you must pay back the money that you stole. That takes another lawsuit where you sue a person civilly. And so for breach of contract, the contract was an employment contract, and they had duty in that employment contract to not steal, but to protect the company from being stolen from. And as a result, their violation of the contract and the loss, the calculated loss, can result in damages or paying the money back. They also sued the agency severally. So when you say it's joint and several or joint, if it's joint, it means we're suing them together and you guys share in the responsibility. If it's severally, then you sue the person separately to say the agency bears some responsibility all on their own. And usually you would sue someone separately, an additional lawsuit, a separate lawsuit, because you just don't believe that the other party on their own could pay, will pay, or that you might even succeed against the other party. And the tort, a liable tortfeasor. A tort is when you knowingly and wittingly violate the term of a contract causing harm to another party. And that you had a reasonable expectation that it would cause harm to the other party. At trial, the treaty group was successful against the agency. So in this separate lawsuit, the original lawsuit was for a lot, maybe $260,000. And then the treaty group the agency appealed it, and they went back and said, hey, we've been sued severally, and we can't be held liable for every bit of this. I mean, the employee's got to take some responsibility for their theft. We can't be 100% responsible for the theft. And they got a good portion of the damages reduced. So there were a couple things that happened. A few things that happened. One, there was no signed service agreement. It was all done verbally. And there was an intermediary consultant. So the treaty group had hired an intermediary consultant who was helping them out with business practices. And the intermediary consultant said, don't worry, look, I'll look after some of that. I'll help you find the agency, and I'll help do the reference checks. And I don't really think that we should get the agency to do the reference checks, because they're all liars and they exaggerate a person's qualifications. So if I do it independently, then we'll know that it's an objective reference check. And then there was this legal battle over what the difference was between a reference check and a background check. And then a reference check may not have uncovered the fact that the person had been fired from their jobs, because even some of the companies that they're doing the reference checks with were not the companies that the person had committed fraud against in the past. And a background check, which includes a police record background check, I wrote an article last week and published it on one of my company websites about the different types and levels of police background checks. But a background check and a police background check has got basically 3 levels. I mean, there's subsets of them. Even the most basic level would have disclosed that this person had a criminal background for fraud and theft. And there was some possibility of dishonesty regarding references. In other words, there was found in the discoveries a piece of paper, wasn't even a full piece of paper, a partial piece of paper that had some hand scribbled notes on it with the name and contact information of a person in a company that the candidate had worked for before, and maybe some check marks and things on it, suggesting that this person had been called, or attempts to call this person had been called, and that if the person had been called, there was some information there that maybe was withheld and maybe is the reason why that piece of paper wasn't a full piece of paper. Nobody really knows, but it was fishy. Um, there was a question about industry norms, which was part of the report that I held about, well, what is a background check? What is a reference check? What is a police background check? What type of jobs are background checks? Who normally performs the police background check? How is the information shared? Is the report actually provided to the people, or is there just a certification sign saying that we got the check and then it's fine? Um, who does the reference checks? There were some issues about guarantees and how long they last and fees and that kind of stuff. So what were the industry norms? There were questions about the agency's website and the pages. There was an agency that did temporary contract and permanent recruitment, and on the pages that talked about permanent recruitment, it talked about all of the things that the company did. And so did that constitute the contract? If you say to the public, if you run an ad that says 100% guaranteed satisfaction, if it doesn't clean your dishes, we'll give you 100% of your money back. I saw a commercial for a clothing detergent the other day that offered to give 100% of your money back if you weren't 100% satisfied. And I wondered who bought detergent for their dirty children's clothes, or children's dirty clothes, and then went back to the grocery store and said, look at my thing. Oh, it's not clean enough. But having some promises on the website, does that constitute a contract? Is that the bare minimum standard that everyone can expect to receive? Um, there were some issues about the client's business practices, their lack of checks and balances. How did they not know for 2 years that they had $263,000 being dribbed and drabbed out of their bank accounts? And there was obviously some parts of the case. In case you have, I hope you never have, I hope you never do have to go into a tort liability lawsuit for damages for breach of violation of contract in contract law or corporate law. But basically what happens is you have your argument over, first off, what laws apply. You have an argument over what the facts, you have disclosures and arguments and viva voce evidence, in-person evidence, of what the facts are. So we determine the set of facts. Then there's some discussion by the lawyers about what laws exist, contract terms exist, contract law exists, common law exists, website promises exist, that apply to the facts. And then the judge or jury decides who's guilty. And then there's this discussion about how guilty are they? What's it worth? What are the damages? Very often there's three components to this, and a lawyer can correct me if I'm wrong on this, but generally it is what was the damage? Can we calculate it? What is there any penalty for intentionally violating the contract or the law? So is there something punitive in nature there? So when we hear about these cases in the United States, $1 billion lawsuit for calling somebody a liar, the first part about the damages, that's almost impossible to prove. And then there's a punishment for saying bad things about people. And so untrue things about people. And so there's the punitive part, and then there's the costs part. And usually the party in Ontario and Canada, we call it Rule 49. In Ontario, we call it Rule 49. And this is where we determine which party is going to pay for the other person's legal expenses. And the expenses of discovery and of forensic accounting and going to court and court fees and all that kind of stuff. And so we've got these three parts. We've got the damages, the punitive penalties, and the costs. And at the end of the day, there was this big discussion about damages and costs. What portion of it was the company responsible for in terms of the damages, and how would they share in those costs? And so, the rules, the things that we learned from this is number one, was the agency telling the truth? Number two, was the customer and their consultant telling the truth? Number three, was there a contract? Number four, if there is a contract or there are common law issues or promises made on a website or on the back of a timesheet, do these constitute a contract? And did we uphold our part of the contract? Um, what steps do we take in order to ensure that the promises we make are the promises that we can keep? I mean, there's a whole litany of legal obligations that are affecting the agency. The customer wasn't so right. The candidate certainly wasn't right. So we've got three parties in here, everyone violating some standards, norms, and practices to create this very expensive problem. Examples of what not to do. So we don't want to make up references or ignore unfavorable ones, like maybe that little piece of paper that got ripped in half. Alter or fail to disclose unfavorable test scores prior to presenting the profile to a candidate. You guys remember, maybe you're too young for this, but programs like Quiz and other evaluation programs where we sat people down and we got their typing speeds and their knowledge of Microsoft Excel and other things. And what if they didn't type fast enough? Did we just tell them, oh, we know, geez, you did so good. You did 49 words a minute. With a little bit of practice, you could get that up to 60. Do we withhold that from the customer? Not seeking out approval from a candidate to submit their resume to a client. We've talked about that. Falsifying background screening. We talked about that in the leather treaty case. Missing a step in all of this. So sometimes it's not just that you take an action that is illegal or unethical or immoral or fails to meet the principles that we set forth. Sometimes it's an inaction. It's what we didn't do that was tantamount to being illegal or unethical or immoral. And so it isn't only what we do, but sometimes it's what we don't do that also falls into the judgment of our behavior. Excuse me. Principle number 4, we will supply candidates and employees with complete and accurate information as provided by the client regarding terms of employment, the job descriptions, the workplace conditions, the number of weeks of vacation, the benefits, all of the information. Accuracy is the twin brother of honesty. So when we fail to be accurate, we fail to be honest. So in this case study, we placed an employee with a client as a data entry operator, and it was an alphanumeric basic typist. When we contact the employee a few weeks later on their assignment, we find out that they are not only doing data entry, but they are also using more sophisticated software like MS Project or something else. Track milestones for their manager, and they're working in Excel, and they're doing pivot tables and lookup tables, and they're running analysis and doing far more sophisticated work that was in the original job description. Is this a moral conundrum? Is this a violation of the code of ethics and standards? And the answer is probably not. If the client gave you information and you believed it to be true and they thought it to be true about a job, whether it was a temporary job or a full-time job, with a pay rate and so on, the place of work and hours of work and working conditions. And then when the candidate got there, they found out, boy, this is a smart candidate with lots of skills. Let's see if they can help us out with this thing and that thing. And the candidate excels at it. This doesn't necessarily mean that the original order and the order fulfillment was done in an unethical fashion. Now, in some cases, like For example, in a union environment, the union is very particular about classifying work because they know that they think that, they believe that, they take the position that employers will take advantage of an individual's skill, knowledge, experience, and abilities by declassifying or low classifying a job so that it meets the pay rate level of, say, clerk level one, when in fact they've got the ability to and do in fact perform the duties of a clerk level five. And they think that their position is that employers will maliciously and intentionally take advantage of the vulnerability of workers by lower classifying them, misclassifying them into a lower paying job, and that if we don't stand up for the worker, what is the union's purpose? And so, if that is the culture and the contract between the employer and the union in your organization, then so be it. It's it maybe didn't set out as being an inappropriate conduct, but it has evolved to be that, and the person would be entitled to make application for a higher status of worker. But that's not the way that most. I mean, first off, it says we placed an employee, so I don't know if this is a temporary assignment or a permanent employment. The most of the time we don't have in our industry these rigorous standards that says here's a clerk level 2 and they get paid this and billed that, and here's a clerk level 3 and they get paid this and billed that. We do say, for example, in government contracts, and we do sometimes in big RFIs and RFPs for banks and insurance companies, but whether or not those people are really systematically appropriately placed or not is sometimes not given a lot of priority. And so it didn't set out to be an unethical thing. And based upon what the rules and the regulations and the policies and the traditions and the culture of the organization will determine whether or not this has kind of evolved into an ethical problem. It certainly wouldn't be an unethical thing to say, hey, customer, I hear that Mary's doing a great job and she's now doing a whole bunch of things and she's doing stuff of a senior level clerk. Would you like us to give her a raise and raise her rate from $20 an hour to $22 an hour, or from $22 to $25 an hour, or whatever, and to adjust your bill rate appropriately? I think it only sounds fair, and see how the customer responds. Now, in a unionized organization where this is a very rigorous rules-based thing, then I think that you've got a greater obligation to do that. But if it was a permanent job, not your place. If it's a temporary job, could be your place. So this is one of those cases that doesn't have a straightforward answer, but I've given you some talking points. I mean, I've talked through some points to let you think about the issues that you should be considering. Here's one. A temporary help agency is required to provide the following information to an assignment employee when offering a work assignment with a client. So we talked the other day when we were doing the Employment Standards Act 2 sessions ago that there are special provisions specifically in the Employment Standards Act, I think from around 2004, 2005, when the the ESA was modified to include special provisions concerning temporary help workers. And it says that we have to give them the legal name of the client and the contact information for the client and their address and their phone number and their contact names. We have to tell them how much wage they're going to be paid and whether it's commissions or benefits and what their hours of work are going to be and the general description of the work. So there can be a congruency between what we talk about on the phone or what we went back and forth in text messages or emails and what really happens. This is to hold you, the agency, accountable to the promises that you make to the workers. And so, in one of our companies, we have an app that all the employees have to have. And once they've agreed to an assignment, it sends them all of this information in the app, and they click on the assignment and they accept it, and it's all there. And in another one of our companies, the job order system, the moment that a person over the phone or whatever received the stuff where there's so many candidates, not everybody has the app right now, right away. Takes some time to get them onboarded into the app. That we immediately this go send the candidate their confirmation letter, and it sends them the confirmation with all those details of this information in an email directly to them. And so the law says that we need to send it to them the first practical opportunity. It doesn't mean at the exact second that they accept the job, but at the most practical opportunity. Principle number 5, we will not recruit, encourage, or entice a candidate for whom we have previously placed to leave employ of our client, nor will we encourage or coerce an individual to leave any temporary assignment before the stated completion date. So this is an interesting thing. So we talked earlier about the anti-rating clause, not to place a person into a job and then turn around and go ahead and recruit that same person out of that company and place them somewhere else, or to not place a person into a job and find out about who their supervisor or coworkers were in the course of doing that placement, and then use that information in a way to cause harm to our client by recruiting those people out and placing them with a competitor or another company. But under what circumstance would you entice a candidate or employee who has been previously placed with your client to think about one of your jobs? And would it be when you place the candidate at the clients and the position has turned out to be less than the client promised? No, we just talked about that example. It might be important for you to intervene, to ask the question, do you think you can give them a raise? They're a little dissatisfied, to help to make things right. But certainly the solution is not to recruit them out of the job of which you were hired to place them into. When the candidate employee approaches you saying, well, I'm leaving anyways, and I trust that you'll help me in choosing my next direction. Well, the answer to that's supposed to be, geez, I'm really sorry. I can't represent you. I've got a legal and moral obligation to not recruit or entice a person out of a job that I've placed them into. If someday you quit all on your own and you call me, I can put you back into your roster of available employees, but I cannot talk to you about new jobs while you're working for a customer. That's just not right. Is there anything I can do to help you to fix the job that you're in right now? And that would be the appropriate approach there. When the person is obviously unhappy in their current position, well, same answer. When the client is planning layoffs sometime in the future. So if a client says to you, I'm planning to lay people off in the future, and unfortunately the candidate that you placed here last month is going to be first to go, last in, first out. That's our policy. So the people with the least amount of tenure are the ones that are going to go first. And Mary, John are going to be given notice sometime in the next 2 to 3 weeks. The client can give you permission to represent that person, but they probably are not going to give you permission to disclose the fact that there's going to be a layoff. So now you've got a moral conundrum. You've now been given permission that if the candidate asks for representation, you can say yes, but you probably have an obligation to protect the privacy of the company and the confidentiality of the information you have about the upcoming layoff. And so in most cases, there's no circumstances that would be acceptable, except for maybe the last one, but you probably can't do it anyways. What to do now? Some more examples. A recruiter needs to fill another role ASAP, and the margin is higher in this new job. The recruiter wants to pull an employee from a national account where the profit margin is very low. Well, don't do that. You've got an obligation not to remove a person from a placement that you've got them in. As a matter of fact, you don't even tell the employee about that other higher paying job. The employee tells you they have another opportunity and they want to leave the assignment. So your obligation at that point in time is to do what you need to do to try to keep them in the assignment by trying to resolve their problem, satisfy their dissatisfaction, look for a solution to their problem. The recruiter locates a candidate who is currently working for a competitor on a 3-month assignment. They'd be perfect for the job that you have now, and the job that you have now pays more. And The Access Code of Ethics and Standards says that you won't actively entice or coerce that person to leave that job. So calling them up and saying, if you leave it now, I'll give you a raise. That would be considered to be unethical under the Access Code of Ethics and Standards. And the reason, you might think competition is fair competition. Well, the reason for that is there's a lot of candidates in this world. And when you choose to take the path that causes harm to the reputation of the industry. So when the client finds out that you recruited them out of there, and when the client finds out that the agency placed them in there and couldn't keep them there because they underpaid them, there's two good reasons for for you and the other agency and the industry as a whole to be perceived to be cannibalistic and inappropriate in your conduct and causing harm, cutting off your nose to spite your face. And so it doesn't mean that a person can't apply for a job and you post a job and they apply for the job and you interview them for the job and they say, yeah, I'm really dissatisfied. I'm going to be, when I find something better, I'm going to leave. That's fine. That is not coercing or enticing. That's the natural, normal process of a person because people leave jobs. People, they say something like 80% of people don't quit their job, or company, they quit their supervisor. 10 to 20% of people, when they're leaving their job, are seeking a pay raise. And so, there are really two fundamental reasons why people, there are lots of reasons, but there's two fundamental reasons why people leave a company. It's because they're not happy in the role that they're performing or the person or the people that they report to. That could mean that they have a lack of confidence in the company's future, or they have a lack of confidence in the security of the career path that they can follow inside the organizations they've reached. They've been overlooked for, the 3 times now for the promotion. All of those things come with dissatisfaction. And sometimes it's money. Sometimes people feel like they are, and dissatisfaction could mean hours of work, place of work, travel time to work, flexibility of policies and how you deal with your kids and their schooling. There's all kinds of things that can make people dissatisfied. But the second most popular reason is money. And there's people are going to apply for jobs to you and they're going to say, yeah, I really think that I deserve to have $2 an hour or more, at least 5 or 10 or 20% or whatever it might be, more in pay. And I'm looking for another job. And when I find another job that I think I'll be equally happy with, that pays more money, I'm going to leave. That is not enticing or coercing. Principle number 6, we will not restrict the right of a candidate or employee to accept employment of their choice. So when a person says, I'm going to apply for a job with your client, that's between you and your client. If you've got a contract with you and your client, then the client might have to pay a fee. If it's 6 months after the first date of an assignment, then the law says you can't charge a fee. But you can't do anything or shouldn't do anything that says you're not allowed to apply for a job or you're not allowed to accept that job. You are allowed to say things like, look, when we put you into this company, you're going to be given access to private and confidential information, and it's not permitted that you use that confidential information and knowledge for your own personal benefit. And it will reflect poorly upon our company and you if you start applying for jobs inside the company while you're there. If you happen to see something and you want to apply for a job, then please contact us and we'll give you recommendations on your appropriate path forward. That's okay. But if they go ahead and apply for the job anyways, to penalize them or reprise against them would be not only a violation of the law, but it would be a violation of access principle number 6. There are, in the Employment Standards Act, I mentioned to you that there were some special conditions, and we talked about this 2 sessions ago in ESA, Employment Standards Act, in Ontario. Similarly in the province of Quebec, but not all exactly the same in the province of Quebec. But the common law responsibilities and civil law in Quebec apply specifically also. That there are special rules about employment relationship in Quebec and in Ontario. The employment agency is the employer of record. A work assignment is the place of work that a person goes to, but it does not, the definition of of work assignment, but does not change the nature of the employment relationship. The employment relationship remains to be with the agency and not with the client at the work assignment. And the end of a work assignment does not necessarily constitute the end of employment. A customer can say this assignment will come to an end, but only the agency can say this employment relationship will come to an end. There are special record-keeping requirements, which, by the way, are pretty consistent with all the record-keeping requirements of all other companies. However, they chose to put it down in this section for employment agencies because saying it twice and more specifically for employment agencies reinforces the fact that we are the employer. Now, sometimes things like saying it twice, saying it over here in the original act and over here under the temporary help agencies portion again, makes it sound like we're isolating temporary help agencies and making them seem like they're really bad. So therefore we have to do stuff very specifically for them. But really, it's because of this thing that I told you about before, which is the previous elect to work provisions. Before these changes took place, a temporary worker had the right, up until 2001 or something, the temporary worker had the right to elect to work or not to work when requested to do so, which meant that if you offered them an assignment, they didn't have to take it. And if they didn't take it and they had the right to not take it, then these things didn't apply to them. They said, why would we pay termination pay and severance pay and public holiday pay to people who've got the right to say, I don't want to work? Well, at the end of the day, they had the right at the beginning of an assignment to say, I'll accept that 1 week, 2 week, 1 day, 6 month, 1 year assignment. But they did, once they accepted the assignment, they didn't have the right on a day-to-day basis to decide when to go to work and not to go to work. So the original elect to work provision was kind of put there for people who are independent contractors. It's like, I'm an independent contractor. I decide if I go to this customer in the morning and that one in the afternoon, or that one in the afternoon and this one in the morning, or something like that. And so they're basically saying, if you're not really an employee because you've got the right to make all these decisions, then you're not entitled to employee benefits. So a zillion years ago, the elect to work was put into place to kind of deal with this sort of quasi-independent contractor notion. And it morphed and was misused in a way for temporary help companies to say, well, my employee has got the right to elect to work, so therefore they don't get termination pay, or they don't get public holiday pay, or they don't get vacation pay, or something. And so when they removed the elect to work content, they also introduced the notion that said, hey, the employer relationship is in fact. So these provisions were to counteract the previous misuse of the elect to work, to say that doesn't exist anymore. The first provision is that they're your employee. Number one, there's an employment relationship between the worker and the agency. And then it went through each of the areas of the Employment Standards Act where in the past people had said you don't apply, and said, yeah, they do apply. So record keeping is over there for everybody, but it also says, hey, you have to keep it. And the information about the assignment that I listed on a previous screen, where you're going, when you're going, how much you're getting paid, the hours of work, all that kind of stuff, that needs to be kept for 5 years. In point number 3, point number 4 has to be kept for 5 years. We talked about number 5, the information that they must receive. Number 6, we've talked about this earlier, about the provision of charges of fees. So you can't charge a candidate for anything like preparing their resume or finding them a job or that sort of thing. But you also can't charge fees, number 7, to a client from, even if your contract says that there is a workforce transition fee or a liquidated damages fee or a try to buy fee or a temp to perm fee or just a placement agency fee. And sometimes placement agencies say, oh, our fee is 20%. But if you hire them at the end of 1 month, we'll give you a 1/3 discount. And if we hire them at the end of 2 months, we'll give you a 2/3 discount. And if you hire them at the end of 3 months, we'll give you a 3/3 discount. 100% discount on your placement fee. So there's all kinds of ways, different schemes that agencies use and temporary staffing services use to come up with the value of the invoice for a placement. Nevertheless, at the end of 6 months from the first day of the assignment, no such scheme shall apply. In other words, you cannot charge a fee after a person has been there for 6 months. We talked about number 8 says that you can't refuse a reference of a candidate who's worked for you before in the past. All of our workers are eligible under the normal provisions for public holiday. And it also talks about in that public holiday section about continuity of employment, that between assignments, the length of time, the tenure that the person's been with you continues. And so public holidays apply, and the calculation applies from the beginning of the first assignment to the end of the last assignment, to the end of the last day before the public holiday, unless there has been specifically a termination and rehiring in between. Termination of assignment does not necessarily mean termination of employment. Termination of employment means certain things specifically, and it has to meet the standards of a proper termination with notice and pay in lieu of notice. We talked about organizations with a certain size of payroll, and after 5 years of employment, that there's an additional severance pay. The reprisals exist all throughout the Employment Standards Act, but again, they repeat them again in the agency portion, saying you can't penalize a person or reprise against an employee for standing up for their rights that they're entitled to under the law, or for even asking if they have a right, even if they don't. You can't reprise against them. Enforcement of temporary agency rules. So there's a part in the law that says this is how it's going to be enforced, and this is what the penalties would be. And then there's the section that talks about this joint. Remember, I talked about joint and several in a lawsuit. So this specifically makes agencies and the client jointly and severally responsible. So in other words, the agency will be held accountable to make payment of things like vacation pay, public holiday pay, wages, severance pay, termination pay, public holiday pay. These are all different types of pay, and the agency is the employer of record, and so they will be held accountable for that. In the event that the agency cannot pay or does not pay, then the client will be either jointly responsible, in other words, responsible for paying the portion that wasn't paid, or separately responsible. So there are several, more than one parties with equal responsibility, totally responsible for all the unpaid wages of different forms. So this jointly and severally specifically naming the client. So even if the client had paid the agency already, if the agency failed to pay, then the client can still be held responsible. So we talked about prohibitions of charging fees to a candidate, can or do. The agency can't restrict them from attempting to get direct employment with your client. Cannot charge fees to your client after 6 months. Principle number 7. We're going to take a break in 12 minutes, guys. Principle number 7. We will not misuse membership privileges for the purposes of recruiting member staff or in any way that may otherwise inure the candidates, our candidates, employees, or competitors. So what this means is that you're not going to use the ACSESS membership list. You're not going to attend ACSESS events. You're not going to attend ACSESS chapter meetings or conferences or get on a committee and you go there and say, I'm here for the better interest of my company in the industry. I'm here to promote our ethics and standards, and then headhunt from the other people in the room who came into the room, who left their guns at the door, and you came armed for a battle. So for example, the agency you work for has experienced some turnover in their branch and they need to recruit a new recruiter ASAP. So ACSESS association meeting that evening. You're planning attending. You're going to let everybody know. Well, don't do that. The point is this, that it's okay. I mean, it's okay. We're recruiters. It's okay to recruit. It's okay to try to be better than the other guy. It's okay to pay more, to offer better benefits. It's okay to try to be nicer than other people and to be more desirable as an employer. That's okay. What's not okay is to join the association that stands on the principle that we will adhere to a code of ethics and standards. And one of those codes of ethics and standards is to respect the privacy of the information that we share, and then go to the ACSESS meeting and exploit the information that is shared with you. The attendees at the meeting, the members list, the attendee list, the distribution emails, the confirmation of attendance, that you'll use that information to recruit from your partners. We basically say, man, when you're at an ACSESS meeting, leave your guns outside the saloon. Come in and we will all do this together. We'll serve our purposes to share, to find betterment, to raise the standards, to teach each other best practices, to collaborate together towards a safer workplace, to promote the integrity and the reputation of the industry, and that we're not going to go into the room, join the association, participate in the committee on the false pretenses that that's what we're pretending to do while we try to cause harm to the people who came unarmed. Principle number 8, we'll derive income only from our clients and make no direct or indirect charges to our candidates. Do not charge your candidates. We know that. Not even for things like repayments of uniforms or repayments of tablets or phones. If you have a tuck shop or a buy site or something, do it separately. Don't do it from payroll. Principle number 9, we will maintain the highest standards of integrity in all forms of advertising. Communications and solicitations, we will conduct our business in a manner designed to enhance the operational image and the reputation of the employment, recruitment, and staffing industry as a whole. And so when in many provinces, and particularly in the province of Ontario, but in many provinces, legislation has been passed and there's a common law responsibility in order to say, for example, to put your salary or salary range in a job posting. And in some places, it's illegal to post a job that doesn't exist. And in some places, it's okay to, so long as you stipulate and say, this is the kind of job we're always recruiting for. And at some point in time within the reasonable future, we're going to have more of these. Get your info into the inbox so that we can consider you when that job comes available tomorrow. Start the registration process now. So, it would be tantamount. That would be the same as a university saying, we don't know how many spots are going to be available in the fall, but put your application in and we'll let you know whether or not spots become available and whether or not you qualify. It's okay to do that so long as you say, if it is an open job, this job is open now, or 6 jobs of this exact job title are open now, you can say that. But if it's not open now, it's more specific, better for you to say that it's not open now, but it's an evergreen, like I call it an evergreen job. And there's specific rules, very complicated and convoluted about posting of salaries and wages. Integrity in advertising, here's a couple of the things about integrity in advertising, particularly as it goes toward job postings. Keep your job postings up to date. And by the way, best practices. If you post a job to Monster or Indeed or Glassdoor or Career Builder or someplace, or on your website, it loses its freshness when it's not up to date. It doesn't show up in recent searches. The jobs that were posted today usually show up in the searches today and tomorrow. And the jobs that were posted 6 months ago and are still sitting there kind of go stale online, and they don't tend to get as much traction and given as much priority under Google searches and other types of searches. Make sure your post is accurate, that it says the right things about the job. Um, Only post open jobs unless you specified, so the evergreen job. Um, Legislation in some provinces, accurate pay rates or none. But in Ontario now, you're supposed to post something. Now, there's certain jobs under a certain level you don't need to post. You can look at the legislation. I'm not going to go through it for you now because it's very convoluted and every province is a little bit different. Whoops, sorry. Um, this is the part um, that most people don't think about, but it's the unintended human rights violations. The recent graduates implies age. Young, vigorous spirit implies age. Um, Certain wording and gender specific expressions might imply gender. So be careful that there aren't any unintended or implied violations to human rights. It's okay that if you need a Chinese speaking customer service representative to work in your call center to handle um, Chinese calls from Chinese speaking customers, that you say um, Cantonese or Mandarin uh, language spoken is a mandatory requirement. It's okay to say that if it's a bona fide occupational requirement. It's not okay to say that if it's not a bona fide occupational requirement. Always try to protect your client's identity. Boy, you wouldn't imagine the number of people that have taken a job description and a job order and a job posting from a client, and they've been given the job order and they copy and paste it, and it unwittingly or unknowingly, just through a lack of um, attention to detail, discloses who the client is. Protect your client's identity. Protect your candidate's privacy. Make sure that if your candidate has not given you the right to present a candidate to a company or to do a reference check, that you do not disclose their name to the referencee or to the employer. Acknowledge applications when they come in. We got your application. Thanks a lot. This is going to be the process. It's okay to say to people, please don't contact us again. We're going to be looking at the many applications and we'll be responding to a small subset of them. If you haven't heard from us within 15 days or 15 hours, then your application will not be proceeding on this job. It's okay to say we're going to hang on to your application, and that if you don't apply for this, if you don't qualify for this job, we'll consider it for other jobs. It's okay to say that. And new legislation in the province of Ontario is going to specifically tell us that we need to, within a period of time, give people feedback, particularly if they've been interviewed or contacted for a job. Here's my pet peeve. The last one. Pay attention to wrapping and auto posting. So, look, the technology is different for different job boards and different websites and different apps. But it basically goes like this. You have an app or an application or a website or a place, a database where your jobs go in, and they've got fields and they're in there. And so they could be in your applicant tracking system. They could be in, whatever, Bullhorn. They could be in Bullhorn inside your company or something else inside your company. And you've got your jobs in there. And there may be an API, an application program interface, that takes that information and moves it to your website or moves it to a table or a job board or a place where Monster or Job Boom or Indeed or somebody can, what I call, scrape it, grab it, and synchronize it with their website. So there's things like, is there an API? An API is a sophisticated way that creates a standard for which job application or job systems um, any system, for job systems, create a standard mapping of the types of fields and the names of fields, name, address, telephone number, postal code, job title, location, salary, that are standardized. So if they go over to another application, they map directly to the right place. So the salary goes in the salary field and the job title goes in the job title field. And so this mapping is usually a sophisticated process. Some organizations like Bullhorn or accounting packages, they create these APIs so that different programs can interface with them and push and pull data back and forth because there's an automatic and standardized field mapping so that data can go back and forth. They don't always work perfect. And some people change some stuff. And there's no guarantee that if you map it to your website and then Monster scrapes the data from your website, or you have it in your applicant tracking system or your job management system, and that ZipRecruiter is going to take it from there, that you give them access to take it from there, that the mapping is always going to be accurate. These different guys change their technology, they do upgrades and they do all kinds of things. And you might work today, and then you find out that next week that it's cutting off and truncating the location of the job, or it's mixing up all the locations, or it's no longer telling you the salary, or it's putting the phone number in wrong. Look at this stuff. Like, make it a habit that when you wake up in the morning, or when you are riding on the GO train, or when you're doing something at lunchtime, that you quickly go to Monster and Job Bank Canada and Job Boom in Quebec and Indeed and jobs.ca and Glassdoor and Career Builder and LinkedIn, and take a look and say, what do my jobs look like? What do they look like? I was looking for a video today of something I did for a disabled person years ago, and they mentioned it, and I thought, oh God, if I could find that video, I think it's somewhere on one of my social media sites or something like 6, 7, 8, 9 years ago. And I've got a ton. This is an example. I've got a ton of job posting from 9 years ago that website that they were scraping from no longer exists. And so it says, we're hiring, here's the thing, here's the stuff. And nobody's going back 9 years to look at my Facebook account to find out what job exists. But the fact is that it says the words, but that it maps to nothing and it's blank and you can't click on it. So I'm okay with that because it's 9 years old and no one's going back 9 years on my Facebook account to try to apply for a job. But what happens if that happens today? What happens if the link is not correct? What happens if it gets posted to LinkedIn, but that job is no longer there anymore? What happens if it's a scrape or an API synchronization and you change the job order in your internal system? Does it change on the outside? Furthermore, is the mapping and the API and the scrape so sophisticated that it doesn't accidentally or inadvertently, because somebody changed something somewhere, disclose your customer's name or their phone number, their corporate name? Is it formatting it properly? Is it spacing properly? When HTML jobs get posted from one site to another, the HTML codes get screwed up, and it doesn't necessarily put the paragraph spaces in place, or center the thing, or italic the thing, or bold the thing. Look at it and bring it to the person's attention, the technology person's attention who's responsible for that, so you don't look unprofessional. Okay, so in order to solve that problem, use templates and descriptive job titles. Don't just say project manager. Project manager in construction and IT and accounting and education, they're all different. Say whether it's remote or hybrid, put in your salary ranges, and you follow the pattern of having job responsibilities, qualifications, company and corporate culture descriptions, and an application process. So if you've got templates that you use to establish these formats, the amount of effort that goes into it is less. The amount of potential errors that you make are fewer. And if you're using simple things like typing a job description out, using a word processor, or typing it into an application tracking system or into a job order management system, then use AI and spell check it and grammar check it and check your fonts and use your logo for branding. Don't look unprofessional. Keep that job current. Okay, so when we come back, we're going to have a quick talk about social media. It is now 2:34 in the afternoon. We're going to come back at 2:45. So you got 11 minutes today, and we'll see you back here at 2:45. Please don't leave the room. Stay connected. Keep your camera and your microphone off, and I'll see you back here at 2:45. Has any questions? You know that the normal process is just to unmute your microphones and jump in and ask a question whenever you want so that we can deal with it in the moment. But we're going to move along, and our goal is to be done before 4 o'clock today. So social media, we've already talked about social media in some of our previous sessions. And so we have to ask the questions about when are you allowed to use social media at work? And do you think that we can extend some of our rules or policies about social media that extend beyond regular working hours and that extend into people's um, private social media accounts? So we have to ask our employees and set policies that are mindful that their postings will be available to the general public. And we have to remember that once you post something onto social media, it lives there forever. Even after you've deleted it, there's all kinds of websites and ways that people can look at the history and say what existed on such and such a date on a certain site. To be respectful and truthful and honor the privacy rights of candidates and of our employer and of our customer. And if we're going to express our own opinions on our social media sites, but also integrate some things like jobs and job postings and promoting our company and promoting, events in our company, then we need to have a statement, say the views expressed on this website or on my blog or on my Facebook account are mine and they're mine alone, and they don't necessarily reflect the views of my employer. But we got to be pretty careful about these things. We don't want to disclose confidential, proprietary, commercially sensitive information. And we want to ensure, excuse me, that you conduct yourself outside of the workplace that in a manner that would be acceptable inside the workplace. And so if it's going to be available to the public, and if you're going to say on your LinkedIn account, I work for XYZ company, and then you're going to say on your um, Facebook account or your Twitter account, I work for XYZ company, and then you're going to post things that are not in keeping with the policies, practices, and the opinions and the positions of your employer, then this can be cause for dismissal. And so we ask companies to have a very clear and precise social media policy and take into consideration that fact that you might be using company internet, you might be mentioning company names, you might be linking your profile to the company profile, that you may be using a company provided phone, or the company might be reimbursing you for your internet access and your data plan on your phone. All of these things tie together the employee to being under the purview or in the responsibility and the policies, practices, and procedures and expectations of their employer. And so it only goes to make sense that the company has a clear and concise social media policy. Now, from my opinion, is that, we say to people, hey, create a profile that has the same name as your work name, and create a profile and repost all of the job postings from the company and all of the events from the company and all of the charities that you sponsored during the company and all the pictures of the company golf tournament from the company, and promote your company's culture and so on. And then if you need to, have another profile that uses your middle name or your last name. My daughter's a teacher, so she uses her maiden name. She uses her married name for all of the postings that she does for her classroom and for her parents to see, and it promotes the school play and the school musical, and they've got Google School Plays or something, with all their homework and things like that. And those accounts are under one name, and they're not linked to her private social media account. And then, of course, she's respectful on her private social media account anyways. But come up with some policies, practices, and procedures. Be very clear in your guidelines, what is expected, and also respect the fact that people have the right to disconnect, and that and then we've got electronic monitoring legislation in many provinces, particularly in the province of Ontario, but in many provinces. And so you need to be very forthright with people about when and if you are monitoring them. Principle number 10, we will recognize and respect the rights and privileges of competitors in the true fashion of individual initiative and free enterprise, and will refrain from engaging in acts of unfair competition. What the heck does that mean? Fair competition. So there are laws in Canada, federal laws, that restrict us from discussing prices and business terms with competitors. This is called price fixing, and during a bid, so that we do not collaborate together to fix the prices. You've seen class action suits from bread companies and Loblaws about them price fixing the price of bread that was sold over many years, so that the consumers all paid an artificially high price of bread. And under the class action suit, the individuals will all be able to submit receipts or information in order to get money back from over that period of time when it may have been unfair price fixing. Recruiting from competitors for access to confidential information. So it's okay to recruit a competitor's employee, to hire people with experience, knowledge of the industry, training, skills. What's not okay is to say, if you come to work for our company, you must, or you should, or we expect you to disclose the information that you receive that is confidential information while working for a competitor. So confidential information is information that is owned by the previous company, that the information is not available in the public domain. So if you've got a contract with contract terms and prices and a price schedule that existed between one company and their suppliers, and the names of the suppliers and the amount of that the suppliers buy, and what the prices for different categories or job hiring categories are, then having a person come over to you and disclose that information so that you can unfairly compete against them by using their own confidential information that was, for all intents and purposes, stolen, and used in a manner that was intended to cause unfairly benefit the stealer, causing unfair harm to the victim of the crime, to the previous employer. This is often cause for a lawsuit, and can be very expensive and restrictive and cause significant harm to the reputation of both companies. Tortious interference. So this is a legal term that talks about when a third party, not somebody involved in a contract. So there's a contract between ABC Global Company and big corporate customer. And the ABC Global Company supplies temps, say, for example, to a large corporate customer, and they want to go to tender. They want to go to bid. And so somebody, let's say the customer, goes out to the other suppliers who don't have the contract and says, here's all the information we have. This is how much we pay now. This is the number of hours that we have. This number of employees that are there. These are the terms of the contract we have now. When you bid, take that into consideration because we're going to give you all the names and contact information of the temps that are here now that are working for another company and give us a really low price because they're going to become yours. Well, this is the customer basically using confidential information and proprietary information about the employees of another company and using it in an illegal or tortious fashion by breaching the terms of their contract to provide it to a third party. And then the third party uses that information in order to win the bid, unfairly gain the benefit of winning that bid, causing unfair and due harm to the company that had done all the recruiting and all of the hiring and all of the placements and all of the training and so on and so forth. And so this is often called a workforce transfer involving tortious and an illegal act causing harm, interference. Knowingly multiple submitting a candidate. So if you know that a candidate has been submitted by another company to a customer, but you say, hey, look, I know that customer. I'm going to submit that same candidate too. They're obviously interested in that candidate. I know the customer. I'm going to send it over there and see if they'll hire that candidate from me. So that is what we call a multiple submit. And it's a violation of fair competition. Adhering to legislative requirements and contract terms. So always adhere to legislative requirements and abusive market dominance. So abusive market dominance is when one or two companies dominate the majority of the marketplace, which, by the way, doesn't really exist in the staffing services industry in Canada. But if they collaborate together to kind of block everybody else out in a way that they shared confidential and competitive information to cause harm to maybe the customer or to the competitors. Now, here's a funny little story that is not that severe, but you've got a walk-in who comes into your branch and says, hey, I saw an ad and I'm looking for work, and you find out the person doesn't have the skills that you're looking for. But you're aware that your competitor down the road often or always or does currently have a job posting. So for that kind of job. So what do? You thank the candidate for coming in, you'll keep the resume on file, and you don't mention the competitor. Well, if you never get that candidate's job and you have never had that candidate's job before, it's very rare, highly unlikely you're going to get the job order for what that candidate does, then that would be not very helpful to the candidate of saying, thank you very much, I'll keep your resume on file. I mean, you should keep the resume on file, but you've got info that could help them. Thanks for coming to see us today. Number B, thanks for coming to see us today. We're not recruiting for your skill set. Please continue to look at our website and our job opportunities. Here's my card. Feel free to contact me in a couple of months. Check in. So to say to people, hey, look, we don't usually recruit for this job, but hey, every day, new job orders, new customers, new things. It's hard for us to track every candidate, especially when we haven't filled a lot of jobs like that before. But all of our jobs are posted on the website. We got that RAP API scraping thing. All of our jobs are posted on the website. Here's my card. Here's the website. Watch it every day. If you see one you think you're interested in, call me or email me or text me or something. That's a good answer. Thank you for coming in today. Number C, thank you for coming in today. Unfortunately, we're not recruiting for your facility. Here's my card, our company. Check our website. Good. I also noticed that ABC competitor down the road had a job posted exactly for that today. I know Mary down there. Go talk to Mary. See if it aligns with your skills. That's okay thing to do too. It's okay to help people to find a job. Especially, you don't have to think of it like, oh my goodness, I'm being unfaithful to my employer. Your employer had no potential or no realizable, meaningful benefit that was going to come from having this candidate all to yourself. Give people information, give them advice, help them out, help move them along. Thanks for talking by. We're currently not recruiting for your skill set. Goodbye, good luck. Well, that's sort of kind of like tantamount to the things that we do when we post a job online and we don't respond to anybody about anything. We just only call the one or two or five candidates that we think are good ones. So I think the good answer is both B and C. Thanks for coming. Check our website. And thanks for coming. Check our website and go visit Mary down the road. Two good answers. Principle number 11, we will ensure that our clients, candidates, employees are aware of our duty to abide by the Code of Ethics and Standards, and that such supporting policies and guidelines as may from time to time be adopted by the association, we too will undertake to bring any potential infringements before the appropriate association body. And so what this means is that you're promoting access. You're telling people it matters. We are a member of the association that stands for the Code of Ethics. We write the Code of Ethics. We've got a certification course that we've taken that ensures that we understand what industry ethics policies and best practices are. And we're going to do our best to promote the value of that in our company, me as a person professionally, and as our company and as our industry. And so we've got some other examples. For these people are going to come to work at a table of an upcoming conference. They're temps. The conference is expecting a whole bunch of people, 1,000 people, and they want people to work at the check-in counter and give out swag bags and register attendees. The conference outline is about companies promoting ocean fishing and everything from themes from geography and ocean currents to equipment and ocean safety and environmental impact. I'm not sure why that's relevant, but at the welcome table, greeters will need to wear a uniform of a white blouse and a black skirt. So, of course, this implies that the attendees must be female. And so that would be a violation of sex, gender under the human rights laws in every province and federal government. And so the appropriate thing is to say, here's our job description, here's what we're going to do. And people must wear a uniform of a white top buttoned with a collar and black bottoms, either a skirt or pants. That's easy to do. And so now we go back to culture. Hey, I'm going to reword that a little bit because if we only put blouse and skirt, then it's implying that it's only female candidates. And of course, that's going to open us up to scrutiny and you up to scrutiny for violations of human rights. And so let's reword that one thing to a uniform of white top, collared shirt with buttons, long sleeves, and a black bottoms of either pants or a skirt that are black. The candidates must be able to wear this every day at work. And do I have permission to modify that slightly? Well, you go. I don't even know if you need to inform the customer that you're going to modify that slightly. But I think the good practice would be that you're going to modify that slightly, and why? So that they don't continue to go on making the same mistakes. So wrapping up part one, we went through the 11 Code of Ethics and Standards. But here's the things that you could do. You could audit your internal documents and your practices, and you could ask yourself, do all of these documents and practices comply with our 11 codes of ethics and standards? And you can review your service agreements, your contracts, your employment agreements with your employees. And you could ask, does it have the part in there about the social media thing? And does it have the part in there about monitoring their devices? And does it have the right to disconnect in there? And does it talk about in our temp employment contracts about what they're eligible for and public holiday pay and vacation pay and how it's calculated? Do we do this thing right? Have we got templates we already talked about this, for job postings to Um, Standardize the right stuff and avoid the opportunity to make mistakes. Provide thorough training to our employees to ensure their awareness of all of this that we're talking about, our legal expectations and professionalism, to promote a culture that influences the treatment of all candidates and employees without prejudice, to create a code of ethics or operating guidelines that could be based upon the ACSESS code of ethics, but yours could be higher and probably should, to ensure awareness and adherence to them, and post the ACSESS code of ethics in your workplace. So what are we going to do next? Business practices and operating guidelines, and we're going to talk about managing your business. We're a little bit behind schedule, but we will get done on time, I promise you. So operating guidelines are available on the ACSESS website, and you can log in and look for things like workforce transfer guidelines. So these are the guidelines for when that situation arises where large customer or customer with many temps is going out to tender or contract renewal, and they have got a number of contractors or temporary workers on site. And we have to ask, well, what's going to be if a new supplier wins this contract? Do all the assignments end and new people come in? Is the customer going to hire these people because they've been there for 6 months or longer into full-time jobs, and the new contractor only gets the new assignments? Are we going to transfer some of these people over from the old existing contractor to the new contractor? Are we going to transfer over some? Are we going to keep them? If we get a new contractor, are we going to keep the existing people with the existing contractors to the end of their natural assignment and only give the new orders to the new ones? There's all kinds of ways to approach this. And there's all kinds of standards that we'll talk about a little bit more, trying to make sure that it's done right. You should have guidelines, and ACSESS has got guidelines on providing services during a labor dispute, about determining the right of placement if there are more than one agencies that have supplied the same candidate to the same customer. We talked about headhunting staffing professionals, so recruiting from the industry and from ACSESS members, compliance with the Competition Act, assignment of completion dates to all of our orders so that our candidates know when their completion date is going to be, about hazardous materials and workplace employment records so that we can teach people about WMIS and ensure that they understand who the employer of record is. And then, of course, a discriminatory order response. So all of these and others, including application forms, are all on the ACSESS website, and you can find them under operating guidelines. And you can look up, by clicking on each one of these, some more details about each of the guidelines. And so we're going to talk about a few, which we've already talked about to some degree. So, for example, with respect to managed service providers, ACSESS members are expected to present the highest standard of professionalism in the staffing industry, adherence to fairness, integrity, common sense, respect, and sound business practice. We will provide value to employers, candidates, and staffing systems to ensure professionalism with MSPs in an MSP partnership. The following procedures are recommended. So first off, what's an MSP? So managed service provider is when there's one staffing service that's kind of like the gatekeeper. They've got the contract that they either get all the orders, post all the orders, sub-suppliers are needed, and so they roll through the managed service provider. Sometimes the MSP is on site. Sometimes the MSP supplies software that does that. Sometimes the software is vendor neutral, which allows any supplier to submit their candidates, any authorized supplier to submit candidates. They're all treated equally. Sometimes they're biased MSPs so that the multinational company gets first crack at it, and then second crack comes from the sub-suppliers. So things like fees and terms of payment should be discussed and documented in advance. So is the MSP taking a cut? Is there a percentage? Is there a markup? Is there a markdown? Is there something? A documented vendor fee should be on file. A documented markup policy. So some customers say, hey, If you're going to put people into this call center, they all have to make $20 an hour. And you must pay your people $20 an hour. And we don't want to have people in here from 10 different companies all making different amount of money. You guys bid and compete on your bill rate, that's fine, but you don't bid and compete on your pay rate. Normally, that wouldn't be allowed because the employer sets the pay rate. But as a customer, they can say, hey, we're not going to hire anybody unless you pay $20. So pay rates may be discussed and deemed and not deemed to be collusion in an MSP situation. So if you're standardizing pay rates, it's not considered collusion. Discussions that take place in a vendor neutral or MSP environment may include pay rates, markups, business processes. This is all very transparent. And because of the nature of the manner in which the contract is managed, it is deemed to be competitive because you went through a competitive process to determine who the MSP was going to be. And then from then on, it's business process and standards. And so it's not considered to be collusion and a violation of the Competition Act. Suppliers are expected to fulfill customer and MSP vendor neutral requirements in good faith. So if you say it's vendor neutral means that you've got a MSP software in place that puts job orders out to multiple vendors at the same time. And those multiple vendors submit their candidates, and that the application might vet those things and narrow it down, and customer hiring authorities go online and take a look at it. And so if we tell everybody it's vendor neutral, it should in fact be vendor neutral, that not the owner of the software, the manager of the software, or the favored vendor gets first shot and other people don't get first shot. MSP vendor neutral providers are expected to maintain confidentiality throughout the program. So when an MSP is one of your competitors, they get information about your candidates and they get information about your pricing and how quickly it took for you to respond. And so it's enough for maybe them to have that information in the service of that customer, but that information shall not be used in any other way that it was not intended for. So you wouldn't go out and bid on another contract, say, hey, we're the MSP for a big company, and we happen to know that these 6 other supplying staffing companies suck because they cost too much money, and this is how many they have a high non-fill percentage. So using the information in a competitive fashion, violating the confidentiality that was intended to be inherent to the MSP process would be considered to be very unethical. And probably a violation of the terms of the contract if you're smart enough to get it written into your contract. Replacement worker guidelines. So develop an internal policy that requires so this is during a collective bargaining dispute when there's a strike or a lockout. Now, I think the next screen or one of the next screens will tell us that in many provinces, it's not against the law to provide replacement workers during a strike. In Quebec, it is. The federal government has just introduced legislation saying that it is against the law. But in most provinces, it's not. So your customer goes on, the employees go on strike. Now they're saying, we want to stay open. We got to fulfill these orders. People are going to have to cross the picket line. So first, develop a policy and have an internal approval policy that requires a senior level manager to approve those orders and your process before the junior level recruiter down in the bullpen starts filling those orders and dispatching workers starts to client. So make sure that you've got a policy that says, hey, in these circumstances, the boss needs to know. In the province of Quebec and in the federal government and a couple of other provinces, the labor code, le Code du Travail, prohibits the provision of services during a strike, so you can't do it anyways. Respect that a legal labor dispute or a strike or a lockout is a matter between the union and the company's workers. And it's not the function of a temporary staffing service to intervene or attempt to influence the outcome. Because if you said, hey, our goal is to help the company crush the union, that would be inappropriate. Imagine otherwise. You say, our goal is to embarrass the company by sending, unqualified temps. Why would you do that? Um, so that we could crush the company and help the union to make their case. And not our role to get involved, to try to affect the outcome. Consider the adverse effects of participating in such types of business. Consider the health and safety risks of a picket line. You're sending people to cross a picket line. Do they get taken across in a bus with security supervision? They asked to walk through the picket line and get whacked on the head with a stick? Did you provide security? Have you provided supervisors? What about the safety of the work site? If the workplace health and safety officer is a member of the union, they're out there walking the picket line, how do we know that your temp, when they show up the first day, is going to put the guard down on the saw or wear their safety glasses or not do something unhealthy with their respirator? The people who watch over health and safety are out on the picket line. So consider the health and safety and the risks of the picket line and of the supervision at the site. Consider the possibilities of the labor organization, the union, rising up and reprising against you and the industry. Think about it. Are they going to call the media in and say, the ABC staffing company sent scabs here today to unfairly affect the outcome of this union, and the poor workers have been underpaid for 1,000 years, and this was their only chance to put food on the table for their children, but the temporary industry has come to dash their hopes away. These are the things that unions do. These are the things that the media does to get clicks and advertising. So consider the possibility that they're going to create the impression upon the legislators, the government lawmakers who might buy into those storylines and then affect legislation that's going to stop you from doing it in the future. Consider your business case both now, in the short term, and in the long term. Are you going to get the business now, but then when the union workers come back to work to say, we will never use that staffing company ever again, while we were out walking the picket lines, they were supplying scab laborers? Consider that. If you choose to proceed, give your employees full disclosure about what undue pressures or influence they might receive while they're there, and don't put any undue influence or pressures on them to accept the assignment or to remain in the assignment. Just be open and honest and transparent, and make sure you're watching out for the rights. So the federal government, the Liberal government, last year introduced Bill C-58, which makes it illegal for federally regulated employers. So that's interprovincial transportation and broadcast companies and telecommunication companies and banks, for them to use any type of temporary help as replacement workers. Now, there are some provisions that will allow for exceptions that would appear to be exceptions. They're not really exceptions. So, for example, if a person who was on in the collective agreement went on maternity leave and you supplied a temp under the union agreement to replace that person, and the replacement worker is already there and they're not part of the union and they don't go on strike, they can continue to go to work because you're not taking a new order. You're not facilitating some sort of union job replacement. You've already, under the terms of the union agreement, been allowed to put that replacement worker in place, and so they can continue to go to work. Consider their health and safety. Consider the implications, but they're allowed to go. If they're an independent contractor, obviously they're not part of the union, and they're allowed to go. But don't allow them to misclassify new jobs for independent contractors to replace the workers. That would be scab labor multiplied by 10 in badness, because now you've misclassified a worker to be an independent contractor to replace a person who's out on strike. So there are, in the new federal legislation, there are penalties up to $100,000 per day for these violations. talked about the exceptions. And there's some provisions in there for your organizations and staffing companies and employers to negotiate to try to figure out what's going to maintain safety and what's going to do the right things for the right people. We talked about the workforce transfer. This Thompson Tire company has got 60 temporary workers. And the policy that's in place is okay. We don't go into the policies in place. So, if you go onto the ACSESS website, you'll see that there are several guidelines. Number one is one of the guidelines is at the earliest opportunity, inform the workers. Hey, you're here working at ABC Bank and you're our employee, and we've had this contract for 5 years, and the contract's coming up for renewal, and we're going to bid on the contract, and there's a possibility that we may not win the contract. And if we do win the contract, this is great for all of us. If we don't, we're going to let you know immediately. So if you hear rumors, this is what's going on. Number two, we lost the contract, and we've got 90 days to come up with a solution. And so we'd like to ask you for permission to, what would you like to do? Would you like to continue to work for us and have us find you another assignment? Would you like to end your contract at the end of the 90 days? Or would you like us to provide your information and transfer you to the new supplier? You can give some options to your workers. You have to ask them for permission to disclose their information to the new incoming supplier. They might be approached through a bit of a tortious interference where the new supplier might come on site and say, and go walk up to everybody's desk and say, hey, I hear you work for ABC Company. We have the contract. Fill out this form and you can continue to work next week. So, make them aware of the fact that that might happen. Talk to your customer about your customer providing notice to people inside the bank so that inside the company. So that I say bank because it seems to always be banks inside the company, that they know what's going on. Come up with a agreement between the company and the incoming supplier and the outgoing supplier. I always liked the solution that the people who are on assignment remain on assignment until its natural end, and that every assignment has an end date to it, and that the worker has the right to continue working for us at the rates that we used to be, and then all new orders go to the new company, and all existing orders work out to the end of their natural conclusion through the existing companies. I like that solution. Sometimes there's a solution that they become an MSP, that everybody gets paid the same, billed the same, but effective 3 months from now, 2 months from now, 60 days from now, we invoice the master vendor, and the master vendor bundles it all up in their invoice. They send one invoice to the customer. That's another good solution. A bad solution is that you recruited 1,500 people to work in a company, and that effective 30 days from now, new company, no expense to them, gets 1,500 new employees. And as a result of not having to incur the expense of recruiting and building that workforce, they got to lower their price to a tiny little markup. That's a bad outcome. What is a bona fide referral? So we talked about a bona fide occupational requirement. So this time we're talking about what a real, accurate, and truthful presentation of a candidate is for a job order. So, when a staffing company confirms by email or by telephone that they're going to be sending a candidate over. Hey, Mr. Customer, Steve Jones is a pretty good candidate. We're going to send him over. Is that a bona fide referral? Can you put a time stamp and date on that phone call that we're going to send you a candidate for your job order, and here's his name, and then you protect that candidate? No, I don't. That's not a good bona fide referral. The customer agrees to accept the introduction of the candidate and their resume from the staffing company. So the staffing company gets the job order. The candidate says, yeah, you can send my resume. You send the resume to the customer. The customer says, Duly received. Thank you very much. We'll review it and get back to you. Okay, there's a bona fide referral. The staff and company number C informs the candidate of the name and the location of the employer, including the name of the individual to whom the candidate will report to for an interview. Well, this is an integral step in the process that you get approval from the candidate to know where you're sending the resume. So that's a step in the process. That's part of the bona fide referral. D, when the customer is informed of the candidate's name and qualifications, or a resume has been sent to the employer and evidence of the timing of receipt has been established. That's an important part of the process. So basically, B, C, and D are good ones. It's not A when we say, I'm going to send you a candidate. It wouldn't be a bona fide referral if you just sent a resume without permission from the candidate. It wouldn't be a bona fide referral if you just fired it over there without a authorization for a job order. If you just heard they had a job opening and you sent it over there and then said later on, oh, what, you interviewed my candidate and said, well, we didn't give you the job order. So you have to establish that you got the job order. You have to establish you got permission from the candidate. You have to establish that you sent the candidate. You have to establish that they received and acknowledged and time-stamped the receipt of that candidate. Now we've got a bona fide referral. Excuse me. So there's two companies that submit the same candidate. Who's entitled to the fee? Well, the one that sent it first, the one that met all of the requirements. Let's say, for example, both companies got permission from the candidate. Both companies had the legitimate job order. Both companies sent the referral. What is wrong with that candidate? Why did the candidate not say, I think that's the exact same job that I gave permission to ABC company this morning to submit on. I think you better hold off. What's wrong with that candidate? And so then it starts to come down to, once everybody's met all the basic requirements, who did the work? Who scheduled the interview? Who debriefed after the interview? Who prepped the candidate for the interview? Who did the reference checks once the interview was completed to do second stage reference checks? Who went out and collected all the information? So we've now got a situation, and you think, how can this happen? It happens. And it happens when you've got straight commission salespeople all trying to get money from something that they learn about. If you didn't know what to do, well, you would first go to the ACSESS website and you look under best practices, policies, and practices, and under specific guidelines for the determining right of referral and placement to find out what ACSESS says. How can you prevent this from happening? Well, you can have a candidate, for example, sign a disclaimer that says, I, candidate, authorize ABC Recruiting Company to represent me for the job of boom, 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 whatever the title, or any similar role in the same department at XYZ Bank. And that I authorize them to submit my resume and to represent me for employment and that no other companies are authorized for this or any similar position in the same department that might arise as a result of the submission of this resume. You can have a little disclaimer. You can build it in. You can build it into your app. You can build it into your email. You can send the email saying, I'm going to send you an email. Will you please send me one back that says yes? And you can get around that. You can have a contract with your customer that defines these things. You can document or have a system that keeps track of when candidates received and were sent their resumes. You can have a system that specifically documents every step in the workflow. when you sent it, when it was received, when they debriefed, when you had a call, what you talked about, all the stuff that documentation helps. Call Me Contact Center is a national call center that has 40 of your temporary employees working in their primary city location. You received several calls this week from your temporary employees. They're very concerned and angry. Well, I didn't get a gift card at the holiday Christmas party that took place last week. Everybody got a gift card except for the 40 of us. You know how embarrassing that was for 150 people to get gift cards, but us 40 people all stood at the back of the room with our little glasses of punch in our hand, and they all got chits to take a taxi home, and we couldn't drink because we weren't allowed to get chits. So, we got to ask the question, did you even know that the party was going to take place? What kind of relationship do you have with your customer where you don't decide and discuss and plan how your workers are going to integrate into their workforce so you can make them feel like they're your employees, but like they belong? Have you not even spoken with your customer in such a long time that you didn't even know, or your candidates, that you didn't even know they were going to a Christmas party? Is no news is good news? Is that a good philosophy to support your business? Well, guess what? No news is good news until you get news. And just because you're not getting news doesn't mean you're not going to get it tomorrow. So you act in advance in order to get the good news. Don't assume that all things going right. And if you've had this customer for 18 months, does it say 18 months? Call Me Contact has been your customer for 18 months, for a long time. Have you been in to visit the customer? Have you had conversations with them about what a tripartite relationship looks like and who has responsibility for what? Did they have a responsibility to tell you there's going to be a Christmas party? By the way, I had a customer just last night that 60 of our workers were going to be working overtime, and we knew in advance because they're doing this thing. And they contacted us in advance and said, we got 60 people that have all volunteered to come in and work an extra shift to come in at nighttime. So they're going to work their day shift till 5, and we're going to give them a break and give them some food. They're your employees, nudge, nudge, wink, wink. And so we ordered in, like $600 worth of pizza and soft drinks, and made, because they were working late at night, made taxi chits available, Uber accounts available for them to go home for people who didn't feel comfortable traveling after 10 o'clock at night in the city. And so these are things that, as the employer, we have this ongoing relationship with this customer, and they know that some things are the responsibility of the employer and not of the customer. Now, I could have maybe invoiced the customer for certain things, but at the end of the day, it was still the employer's responsibility to make sure that the employees got it. So when we talk about the employer of record, we talk about things like who provides the specific work site training, and who determines what the pay rate is going to be, and who provides coaching and counseling and manages the workers' compensation account, and who administers the general WMIS and other safety trading programs, provides employee perks like the pizza or the benefits, who supervises the employees at the work site. And sometimes, if it's one temp here and one temp there, it's the customer that supervises them. But sometimes when you've got a whole shift of people working in a call center or in a distribution center, you need to assign which one of your workers is the supervisor, has got the most authority to deal with some issues on site, who's got the right to hire and to fire. And we know that the customer has got the right to end an assignment, but they don't have the right to fire. So having these conversations with your customer matters to determine who the employer of record is. It's expected that staffing service firms, if retaining temporary orders, remit appropriate source deductions. So this is the whole issue of, have you inappropriately classified a worker as an independent contractor when in fact they should be classified as an employee? There are new ethical issues arising from artificial intelligence. And ACSESS is a member of the World Employment Confederation. And by the way, the conference that's going to take place in Toronto in May is a joint conference between the WC and ACSESS. I think maybe the third time in history that they've come to Canada. I think 1999, 2000 might have been the first time that they came to Canada, and we had 1,100 people come from around the world. At that point in time, this is going to be a nice big conference. Part of what we do is that we work with WEC to make sure that in all countries throughout the world that that we have similar understandings of ethical and legal conduct to create a safe and fair workplace that we treat all people with human rights and human dignity and respect in all labor markets. And so it's the WC's belief that artificial intelligence can help humans to facilitate their journey in the labor market. It can be used for good. And to support this goal, they've developed a comprehensive document discussing what those standards are. I apologize for I can't barely read it. But you can find this on the ACSESS website. So all AI systems have human-centric design. They're used in recruitment and employment. By just so you know, by the way, in Ontario and other provinces, it is the law now, or will be the law, or proposed laws in different jurisdictions. Everybody's moving at different speeds. That we disclose to our candidates when AI is being used. So we might say to them, hey, if you apply to this job, please be advised that artificial intelligence is being used in the early stages of the screening process to review your resume, to determine if it contains the keywords, job titles, and work experience that is necessary in order to qualify to make it to the second stage of evaluation for this job. Or you might say, please be advised that the scheduling of appointments is done through an online scheduling system that uses AI to try to find the time, the place, and the method of communication, whether it be a video conference call, a telephone call, or an in-person meeting that is best for you. And then you will be introduced to a human in the process. It's common sense. It's just saying, hey, where are you going to use AI in the hiring process? Just let me know so that I can complain about your AI, or I can complain about a human, or if you explain something to me, I can understand how the process worked. So as part of this whole process for ethical AI, we want to have a human in command, somebody who understands the design of how it's augmenting a human capability, not totally replacing it with a new stream and a new process that we don't understand. So a human needs to be able to intervene and make decisions at all times. Transparency, this is the part I just talked about disclosing where it's used and how it's used. Fairness and inclusivity by design. Hey, listen, AI systems are used in the recruitment industry, and very often we don't know how they work. All we know is we say, is Steve qualified for this job? Here's the qualifications. And then AI goes behind the scenes and comes out and says, yeah, Steve's really qualified, or no, Steve fails to meet the qualifications. What criteria did it use? What did it look at? Did it look at my middle name and see that it's typical middle name from a foreign country? And did it assume that I don't have the right English speaking skills? How did this AI work? AI is pretty powerful stuff. If I write something and I say, hey, please check this for spelling and grammar, it often comes back and says, yeah, we made some recommendations for spelling and grammar, but by the way, the term that you used here is the inappropriate term. We think you meant this, and we've replaced it. So in that AI model, it told me what it was changing and why. And I could say, no, I meant to say that, or I didn't mean to say that. But do we always know when we're using AI what is going on behind the scenes? And the answer is probably not. I mean, you certainly have no idea when you ask AI to take a picture of a button and ask, where that button is from and what clothing it was made on, that how it figured out what and whether it was even correct, or complete about where that button was made and used. So we got to really look behind the curtain to find out what the wizard is doing. Privacy. The use of AI systems in the recruitment and employment industry should comply with all applicable privacy legislation. So, is it possible that AI could have been looking up stuff and found out about people's some private information by scouring their social media account or looking at some records and disclosing some information about a lawsuit that they were involved in or something that was private information? We got to know about safety and security. They can be technically robust and reliable in order to be trusted, so they have to be that. Um, so monitoring and measuring performance and retraining it and modernizing it and retraining it. AI systems get better and better the more you use them and retrain them. But if you allow them to go down a rabbit hole, they assume that the rabbit hole is correct. So in order to protect a person's safety and security and not do something or suggest something or provide information that could influence a person in an unsafe way. Accountability. Deploying AI systems remains at all times the responsibility of the people that deploy it. You can't say, we're seeing it happen right now where uh, it's in the United States. I think there's a person who maybe committed a criminal offense. It might have been a terror offense, school shooting or something. And they found out after the fact that the person had been doing all kinds of research about guns and about things and about murder using, I think it was Grok. And so, the family, the mother, and the student, the young person who committed this crime was killed in the commission of their crime. And now they're suing the AI company for not having safeguards in place, which would promote with the bad behavior and interfere with the safety of their son or daughter. And so imagine if that's done at work. Imagine if the AI system is promoted at work. And just in the last couple of weeks, one of the AI systems was being used by the Department of Defense in the United States. And the Department of Defense said, hey, we want to use this AI system to figure out tactical plans and how to kill people and stuff. And they said, no, you can't use our AI system for that kind of thing. And so they kicked the AI company out. And they hired a new AI company. And so the AI company took responsibility for the manner in which it was going to be used, and they walked away from a multi-million-dollar super contract that probably could have promoted their company into super success. But they said, no, ethically, we're going to walk away from this. So imagine if you're implementing Grok or Copilot or Gemini or OpenAI, ChatGPT, or any one of the AI systems into your company, or you're buying a application software that's got AI built into it, and you don't train it and you don't monitor it, and you see it and it goes down a rabbit hole and it causes a problem. You've got an ethical obligation to ensure take accountability for it. And to offer this ethical governance, to say, hey, we've got different people on the committees and different points of view and involvement from stakeholders and government and customers and employees and everybody who's involved in the decision-making process, so that it's not just the money maker, for example, who takes responsibility for it, or the efficiency maker, or the project manager who needs to get his project done on time, who may have a biased view of it. Building human capacity. AI should be used to appropriately enhance workers and manage the fair transitions through this implementation of lifelong learning and skills development. In other words, are we using AI to replace workers, or are we using AI to enhance their ability to do things? Now, here's the thing. I think. So far, there's no real evidence that jobs are being lost to AI. So far, there's tremendous evidence that jobs are being created by companies that build the server farms and figure out how to create the energy to drive those server farms and build the energy production plants. And they're building nuclear generating plants specifically to drive server farms, and that they're negotiating international contracts, and there's buildings and infrastructure, and that people are learning and doing a better job of writing articles and blogs and website content, and people are learning how to do things on their spreadsheets that they've never done before because AI is enhancing their opportunity, and there's no real evidence that these people are losing their jobs. I think it makes sense that over time there will be a job transition. But just since the beginning of time, is the internet going to replace recruiters? Are job boards, I remember when the first job boards were created, it was going to replace recruiters. And then there became applicant tracking systems, and they're going to replace recruiters. And then there became um, MSPs and other software that are going to replace recruiters. And then we've now got AI that are scheduling and booking appointments and evaluating candidates. And they said that these are going to replace recruiters. And the reality is that those companies and those recruiters that adopt the technology become the experts in using those technologies, and they find ways to enhance and promote the viability of the industry, and things grow. They don't necessarily disappear. We can say that over time, factory jobs maybe were replaced by machines, but is it true that there's fewer factories in the world? I mean, there may be in certain countries. There may have been a shift from one country to another. But is there less factory production in the world than there was in the 1970s because of robotics? The answer is no. We make more things because of robotics. And so more people are employed around the world because of robotics. It may very well be that certain jurisdictions got new, different kinds of jobs, and those kind of jobs went to some other country. But there are definitely not fewer people working in manufacturing today than there were 30 years ago because of robotics. So the fear mongering can be real if we ignore the technologies entirely. But if we adopt the technology and use it ethically to build human capacity, usually the outcomes are very good. So in our final session, as we move forward into our last 15 minutes, we're going to talk a little bit about some things that happen in our businesses. You can go to the guidelines section of the ACSESS website, and you can download far much more detail than we're talking about today about the various guidelines on the website. We've got a process for people to make a complaint about a member company that may be violating the Code of Ethics and Standards. And that process involves a special committee using the executive director and privacy to investigate and evaluate. And I can honestly say that in my experience, of course, it's confidential, so I don't know of everyone, but I'm assured that over the last 20 years, every access violation that has been made a complaint to our company, our executive director and the committee responsible for evaluating the complaint has gone to the company that the complaint was about, told them about the complaint, talked about what should be done and why it should be done and how it should be done. And then in every case, there either was not a legitimate reason for a complaint, or when there was, the company stepped up and said, I didn't know, thank you for telling us. And they immediately took action to kind of resolve things. Tell you a story about Denny's restaurant that is directly and indirectly involving temporary staffing services firms and also the foreign workers recruitment in Canada and particularly in Alberta. And temporary foreign worker recruitment, where we put the temporary foreign worker and an agency recruited those workers, has been the bane of our existence because it's not really temporary help companies. It's more immigration recruitment companies, foreign recruitment companies that have participated in this. And very often those companies exist outside of Canada. So they exist in the Philippines or in India or someplace, and they come to Canadian employers and say, boy, we can get you a bunch of people from our country and bring them over here and help you to, do your labor market opinion and get people into Canada. And they're not usually Canadian companies, but they can be. And this is where a lot of the legislation exists because of this combination of temporary workers, temporary foreign workers, and immigration foreign worker programs. So in the Denny's example, Denny's wanted to hire a bunch of foreign workers because they're having difficulty in the province of Alberta prior to pandemic in 2013 to fill all the jobs in their stores, in the restaurants. And so they went out and got a labor market opinion, and they got authorization to recruit foreign workers. And under the rules of that, they needed to provide certain things like guarantees of employment, and they needed to give them housing and, certain pay levels and so on and so forth. Then the workers alleged that they paid thousands of dollars in recruitment fees to the agency, and Denny's failed to provide the amount of pay and the overtime and to reimburse the workers for their reimbursement fees or for their travel expenses to come to Canada. And so they alleged that this was a breach of the contract they signed that enticed them to come to Canada, and that they had a breach of fiduciary duty. And remember, the fiduciary duty is when a party has got a responsibility to care for the other party, or to care for something, to care for their company, to care for their children. A caregiver and a nanny has got a fiduciary duty to act as if they were the mother, to provide the safety and the well-being and the sustenance and the food and the warmth and all the things that a mother would do. And so the caregiver has got a fiduciary duty to look after these children as if they were their own, if they were a nanny. And so when you violate your fiduciary duty, that doesn't just mean that you didn't do what you were supposed to do. It means that you um, had the duty to do it and either didn't do it, or you used your power and authority as the fiduciary to give yourself an unfair benefit. Excuse me, to give yourself an unfair benefit. So imagine the nanny has got a fiduciary duty to look after children of she's own. And when the children turn 13, they say, oh, I'm your mother, come live with me. And they steal the children away. Well, that would be a person using their fiduciary duty. They're given the power and authority and the opportunity to act like a mom. And then they literally said, I want these children. I want to be your mom. And so they took advantage of the opportunity that the person was paid to build the trust and confidence from the children, and then use that trust and confidence to steal them away. Yeah, there's a story for you. That's an extreme example of what fiduciary duty can be. So fiduciary duty can also be that we've got an opportunity to protect the confidentiality of the customer list. And then you go work, you're a sales manager, and you got a confident or fiduciary duty to protect the confidentiality of who your customers are and the confidence. Then you go work for another company and steal the list. Then you use the list for your own benefit, causing harm to your previous employer. And this is a violation of your fiduciary duty. And so the workers maintained that Denny's was trying to intimidate them from participating in the lawsuit to try to get their money back. So this is the reprisal. And the government gave an order that there would be no repercussions whatsoever, and that they were not allowed to reprise against them. In fact, they weren't allowed to reprise against anybody, even if they opted out of the lawsuit. So if a person put their name in for the lawsuit and then later on said, "Oh, I don't know, I don't think I want to participate in this anymore," then the interference, the reprisal was so egregious that the court said, I can reasonably assume that the reason the person that removed themselves from this lawsuit is because you threatened them. You made them feel like, whether win or lose, you were going to punish them for participating. And so nobody's allowed to remove themselves from the lawsuit, and nobody's allowed to be punished, even if they're not in the lawsuit. So approximately one quarter of the employees opted out of the lawsuit, causing the courts to say, whoa, 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 something's going on here. So the court noted that the temporary foreign workers were particularly vulnerable. They didn't understand Canadian law. They didn't understand our employment standards. They didn't understand the right to not opt out. And so eventually the courts got the parties to settle, and Denny's agreed to $1.4 million. And so the employees who were promised 37 and a half to 40 hours a week, but were only given part-time jobs, were paid their shortcomings. The employees that were promised overtime were paid what they didn't get in overtime. The employees got reimbursed for their airfare. They got reimbursed for their agency fees that they paid to the temporary foreign worker recruitment agency. And Denny's also donated money to an organization that is intended to protect um, foreign workers. So this is the kind of thing that can happen when, so for all intents and purposes, it was an agency that recruited these workers and participated in making promises with the customer, and both the customer and the agency were sued, joint and severally, and in this case, Denny's agreed in the settlement um, to make everybody whole as best as they could. So when we're trying to manage these unethical behaviors with discrimination of job descriptions and breaches of confidentiality and false information and not paying fees and exclusive contracts, we need to try to manage our clients, because in this case, in the Denny's case, it was the client who was behaving badly. And so if the agency had taken the position that it was their responsibility to inform Denny's, to keep them legal, to hold them accountable, then probably none of this would have ever happened. But so we've got a responsibility to manage our customers. We've got a responsibility to manage our employees. The fact that we give them straight commission contracts and leave them alone to do their own thing can really raise concerns about the lack of safety in the workplace, or breach of contracts and breach of confidential information and misrepresentation. Like, who knows what these recruiters are doing? We've given them lots of financial incentives to, in the short term, do the wrong things. And so we need to kind of blend together the incentives that we have to get them to be highly productive, but to not do it at the expense of the long-term reputation and the legal and ethical behaviors of the company, the industry, and the customer. So we talked all about these things, about being deceitful, about stealing away candidates. And the way that we prepare for that is that we have documentations and contracts. And we do our research about what's available in the marketplace, and we go to the ACSESS website and we take a look at what we have on file right now, and we make sure that our documentation is consistent and that our communication is consistent, and we train and make our employees aware of all of the rules and regulations. Okay, so this one, that one we've already gone over. That one about a person applying for a job, and then you have a right to not interfere with their accepting employment from the employer of their choice. Candidates, boy, candidates can be a problem. Candidates can misrepresent their skills. They can use AI to write their fake resumes. They can fake their credentials and their experience. They can misrepresent their salary. They can use a recruiter to initiate a counter offer and leverage their employer to make them stay in their job, and they never had any intentions of leaving in the first place. They can make promises to you and not follow through on their commitments. I'll get you that resume. I'll follow through on the thing. I'll give you the information about my references. I'll do that stuff. I'll talk to my wife and I'll let you know what happens. You know, they can lie. They can circumvent the agency and go straight to the client. They can provide false references. They can provide references of their friend or their sister or somebody who's going to give them a reference for that was never really a coworker or a supervisor in the past. If you're going to submit a complaint to ACSESS, you do it within 7 days. You do it when you know about it. You put it in, you make a phone call first, you discuss it. You'll get advice as to whether or not that is a violation of access complaint. We can't handle a complaint in access unless it's put in writing. So we can't pursue complaints based upon rumors. So you got to put it in writing. Your information and who you are is kept confidential. It doesn't go to the board of directors. It doesn't go to a chapter board. It goes to a special subcommittee that have made a commitment to your confidentiality. Um, there's some timelines that we want to have it done within, so that it isn't like from a year ago or from 2 years ago. We try to resolve it within 30 days. And so the procedure is that it goes to the executive director and an exclusive committee, and that the committee meets quickly. Like, it's not left in the open. So we got 2 minutes to go. I'm going to give you a couple of bonuses. We're going to talk a little bit about insurance. When you sign a contract with a customer, very often, if the agreement is written by the customer, it talks about different kinds of insurance, and you'll hear about these types of things. And it's important that you understand what they are, and that your indemnification, in other words, your promise to make sure that the customer is not hurt, that the promises you make on the type of hurt is covered by an insurance that deals with that type of harm. So, in other words, if you're going to promise them that nobody's going to steal from them, but you don't have theft insurance for a third party or bonding insurance, then you're going to indemnify them from any losses they might incur as a result of theft. That's what the contract says. I indemnify and hold you harmless for any damages that arise from theft from our employees, committed by our employees. But if you don't have insurance that matches that indemnification, then it's a bit of a false promise, or you've put yourself on the hook, and you're going to find yourself liable without the benefit of insurance to cover your liability. So we've got commercial general insurance, or CGL, and CGL often, I call this the Wile E. Coyote insurance. This is when something goes wrong that you just couldn't have anticipated went wrong. A person slips and falls on the ice in front of your place. A product snaps and breaks and pokes somebody in the eye. A person, in the Steve Martin movie, The Jerk, they created glasses that sat out on the end of a person's nose. I can't remember why. And everybody who wore the glasses went cross-eyed because they looked at the bridge on the nose. And they got sued and went bankrupt because they didn't have commercial general liability insurance that covered products. And they got sued under a class action suit for a product that caused harm to people. So commercial general liability insurance often has a blanket insurance, and it's very broad in scope. And I call it the Wile E. Coyote insurance because, that Wile E. Coyote often was running around, and the anvil often fell back and landed on the roadrunner's head unintentionally. And when that happens, you want commercial general liability insurance to cover for the unexpected harm that may happen in the operation of your business. And then they start to carve out some things, like they say property insurance, including fire, water, and theft. So the commercial general liability insurance says, well, we're going to cover everything except the property if it's hurt from fire or water damage or someone breaking in and stealing it. And so we're going to add a clause to it, or a rider to it, that specifically speaks to the topic of property insurance, including fire, theft, and water damage. And then we've got this thing called errors and omissions insurance. Now, there's two types of errors and omissions insurance. One of them is errors and omission insurance to cover the third-party contractors' actions, and one of them is errors and omissions insurance that covers the agency. In the early days, between the 1960s and 70s through to about the year 2000, or maybe sometime after that, most companies had errors and omissions insurance what I call agency, entirely useless. Entirely useless. The only time, so customers would say, you have to have errors and omissions insurance. And so it was one particular company that came up with this errors and omissions insurance, and they came up with it and they sold it to you for like $100. And Then you provided the certificate to the customer because the contract said thou shalt have errors and omissions insurance and supply a certificate of proof. And so they supply a certificate of proof and everybody goes, great. And I used to call this the cost of doing business. It didn't provide you with any insurance of any meaningfulness whatsoever. It didn't protect you from anything. It just helped you meet a false criteria in the contract. Now, the customers really wanted to be covered by the error that the IT contractor or the engineering contractor might make, and the bridge falls down, or the bank crashes, software crashes, because the software developer made an error in writing code and the bank crashed. And or the engineer drew a bridge and stamped it as fine, and then the bridge fell down. So the customer wanted this contractor's insurance that would protect them third party from an error they committed in performing their duties. And yet the errors and omission agency insurance only covered the errors that the agency made. So say, for example, they said, oh, we would like you to send us a candidate who's got an engineering degree in bridge making, mechanical engineer, civil engineer. And so there's two candidates by the name of Steve Jones. One of them is a recruiter and one of them is a civil engineer, and they get them mixed up and they interview the candidate who's the recruiter, but they sent the resume of the candidate who is the civil engineer. And the guy gets hired, gets sent on a contract, and he goes out on this temporary contract. And this poor recruiter, Steve Jones, doesn't know how to build a bridge, so he builds the bridge and the bridge falls down. Well, we could say that the agency made an error in identifying the correct candidate. And so therefore, when the customer sued the agency for the cost of the bridge, then the insurance would cover the error that they made. Ridiculous. Like, when is it that the agency makes a mistake that causes the customer damage? Well, I gave you that leather treaty case. Maybe that might have been it. They made the error on the omission of not doing a reference check and not doing a police background check. That was an omission. They were supposed to do it. They omitted to do it. The person stole. The insurance probably covered them because it was if they had a different kind of insurance. And I'm going to talk to you about that. So errors and omission insurance for the agency covers the errors that the agency makes. Not likely going to happen too often. Errors and omission contractors is when the person you send on assignment makes an error on their assignment, causing damage to the customer. And so this is like a bond where the third party, the customer, is protected by the error made by the contractor. A little more expensive. Then we've got directors and liabilities insurance. And so those are the directors, the president, the vice president, and the members of the board of directors, and the treasurer, so on. The secretary named on the corporate things, corporate documents, that they come along and they're supposed to be reviewing policies, practices, and procedures. They're supposed to be ensuring that the company is financially viable and that they can afford to do things. And then when they fill out banking forms, they're telling the truth. These are the responsibilities of the directors. And let's say, for example, somebody fills out a form and it's wrong, and the bank lends money, and then the company loses money, and then they find out that the company had falsified the information or provided wrong information about something, or they get fail to file something and they get charged. Then the directors could get sued. The company's going to get sued for sure. But into this joint and several, they could join together, the directors and executives, and sue them individually, or they could sue them separately. A perfect example of this is when Clublink Corporation had a policy set by that was reviewed by the corporate executive and board of directors about drinking, and people drinking too much when they're in a Clublink golf course, and that they would not overserve people. And so a bunch of 19, 20-year-olds who were of age, but just of age, at Lake Joe Golf Club came in after golf. They'd obviously been drinking on the golf course. They came into the clubhouse. They were drinking more. Eventually, the servers said, "Hey, we're going to cut you guys off. We can't serve you anymore, and hand over your keys. Nobody's allowed to drive out of here. You guys are all too drunk. You're going to have to call cabs." And they handed over their keys. And then the people went out into the parking lot, and somebody had a set of keys. They all jumped in the car. They drove up the way. There's a bridge. They crossed over the bridge. They're going too fast. They went over the bridge, went in the water. A bunch of people died. It was a terrible situation. Two things happened. The Ontario government tried to pass a law that said that people drinking in places couldn't get their license until they were 20 years old or something, and that was ridiculous. Or that if they were 18 or 17 or 16 years old, that they couldn't have passengers in the car or something. And that didn't work out too well. But the families sued Club Link, and they sued the directors, and the directors got off because they found that they had uh, passed a good policy. The policy had been followed, and even if the policy had not been followed, the policy was good, so they were off the hook. It was the people who were serving the people that might have been on the hook. They found they were all the case, but had they been found guilty, and the defense of that court case was paid for by the director's liability insurance, it didn't come out of the pockets of the directors. Theft and dishonesty insurance, we often say, are your employees bonded? And so bonding is a British term, which basically means insurance for third party. So if our contractor steals from the customer, then that's what in British law they used to call bonding. We've put a bond on the employee, and then we did a background check and a criminal check, and we verify that they're safe and that they're not criminals. And if they steal from you, we've got insurance to cover that what they stole from you. So, the first part of the insurance up at the top, property insurance, including fire and theft, that's when the loss is you. When the employee has got a manifest intent to cause harm to you, not your customer. So that property insurance and theft is when somebody breaks into your place and steals your computers, or breaks into your accounting department and commits a fraud. The theft and dishonesty insurance, bonding for contractors, is a special kind of insurance that you get to cover your temporary workers and contractors when they're out on assignment working on the customer site. And it's basically protecting the customer, making them the first party of named insured, that if the loss is incurred by them, that they get reimbursed for the liability. Professional liability is a special kind of insurance. Every one of them is kind of unique. It could be like if you accidentally broke the law, if you failed to, if you didn't understand your obligations under, say, for example, you violated a privacy law and you got sued, then professional liability would cover that. So when you make an error in, say, it's a human resources policy error, or it's a violation of human rights error, or it's a privacy error, these are all professional liabilities. And so that's special insurance that's not covered under the CGL, the first one, the big blanket insurance. And there's special insurance for things like medical malpractice and caregiver abuse. Again, these are insurances that are designed and recognize that you've got a worker working out at your customer site, and it's ensuring your customer that if the nurse you send out there injects them with the wrong medication, and you sue the nurse and you sue the company, that it will pay to the third party, to the customer, not to you. So these are special insurances, medical malpractice, caregiver abuse. There's other very specific specialty insurance. It can also happen with automobiles. Now, automobile insurance is kind of unique in the sense that typically every automobile has insurance on it, and the owner of the automobile or the leaseor of the automobile holds the primary insurance. So if you're driving your neighbor's car and you crash your neighbor's car into something and you get sued for the damages, then it's your neighbor's car insurance company that will be ultimately and first priority responsible for it. If the amount that they get sued for is in excess of their limits or something, then you can have what's called non-owned automobile insurance. So if my company drives my customer's car, my employee drives my customer's car, and and they get an accident. My customer's insurance, because they've got insurance on their car, covers first. Then there's excess charges and issues and things that come up. I've got insurance that says when my employee is driving somebody else's car, we've got the excess liability insurance that goes above the primary automobile insurance. So you want to have non-owned automobile insurance if you're going to ever let your employees drive a car. And by the way, if you're not in the car driving business and you think that it's possible that somewhere along the way your customer would say, here's the keys, drive this, then non-owned automobile for a non-driving company is not very expensive. Get it. Then, of course, there's workers' compensation insurance, and that's legally required. And workers' compensation insurance is to stop workers from suing their employer if they get injured at work. It's a predetermined liability process and health benefit process that is established that if a person gets injured at work, then you don't sue your employer. Workers' compensation insurance automatically kicks in, and the person might get paid for lost wages or for their medical care and so on and so forth. There's specific terms you're going to see in these policies. One is additionally insured. That means that you're adding your customer to it so that they can make a claim through you. So if the customer gets sued and then the customer sues you, then the customer and you become one. Additionally, named insured means that the customer is primary, not that they got sued and they sued you, but they got sued and the insurance covers them. That's additionally named insured, which would possibly work with medical malpractice and contractors' errors and omissions. We talked about jointly and several times during this presentation. We want to do that. And just in this conversation, I talked to you about indemnifications, which is the promise to make whole, to cover the damages that are incurred to your customer. I indemnify you and hold you harmless. In other words, I protect you from the damages that you might incur as a result of the thing that I did or that we might do. And so you hear the words indemnification. For future discussions and not today, because we are over time. Police record checks. You can go to a blog of mine on ihal.ca and you can find a thing about police record checks there. That has to do with caregivers, but it's all the same. Profiling and personality assessments. We can talk a little bit about that and how AI kind of is involved in that and where it's possible that discrimination might be involved in personality profiling assessments and how they should be used. We can talk a whole day about social media activity. I think that it's possible that we could run a session on counteroffers, how to identify when counteroffers might come and how to prepare yourself against them so that you keep your customer in the process, make the deal and get the fee. We can talk a lot about commission calculations and commission disputes and how it can change the culture and affect the culture of your organization and create incentives or problems, depending on how your commission calculations and systems work. And we've already talked about non-competition fiduciary duty solicitation, confidential information to some great extent. So not for that today. We are 15 minutes over. I'm sorry, I talked too much today, but I also added some more content in the last week, so maybe that should have been expected. I hope that everyone benefited from today. I apologize for going 15 minutes over. And of course, I remain with you online to answer any of your questions. I think we have one more session to do together, and then you're probably going to move on to another instructor for a couple of your more courses. I think sales is our next one. But I know we've gone over. So write down your questions. And if you're going to be here tomorrow for our sales session, we'll put aside some time at the very beginning to jump in to any of these things. I hope you had a great session. I didn't put you to sleep, and we'll talk to you again.